RSA, second appeal. Second appeal will be taking up only on Thursdays and yes, Thursdays and Fridays. Not full month. Yes.
National legal powers, which is powered by the Objections. The matter is the eviction bench
Wednesday. Wednesday. Fourth idre avag move ಮಾಡಿ ಇದ್ರೆ just move beforehand alva it may not come otherwise labor matter
serial number 20
it's call please Sorry, final hearing.
Page number 3, 4, 18 to 22. Is it fine?
My lord, serial number 23, my lordship. Advocate on record is not feeling well, my lord. I'm proxy counsel. I pray for 1 week time.
You appear for the appellant or the
Respondent.
yes.
The advocate.
He is not well anta. So and so counsel submits that N Dayalu is not well. Who is not
Mohan
well?
Kumar D.
Mohan Kumar D. Counsel on record is unwell. At request list this matter on 19th, 20th. Number 2,
I appear for the petitioner, my lord. My lord, this matter pertains to granting compensation for drawing high tension wires, my lord. In the connected matter, my lord has already granted stay subject to deposit of 50%, my lord.
50% or entire amount?
My lord, 50%, my lord. In this matter also, there is an enhancement of 1,54,388, my lord.
Which is
Same
the
matter. It is 20196 of 24, my lord. On 21/8, my lord was pleased to grant on 50% stay, my lord. 50% deposit.
Pay subject to 50% of deposit.
Much obliged.
Who appears for the respondent? Who is the standing counsel? Who is the petitioner in the connected petition? Correct. Who is the counsel appearing in that petition? So and so counsel is directed to accept notice for the respondent. Petitioner counsel to serve the petition papers on the learned counsel. List this along with. Early first serve them, then come. List this along with. Which is that writ petition, main writ petition, which is that? Similar order, subject, entire deposit, subject to entire deposit within 4 weeks from the date of from today, before the transfer.
Number 4, appear for payment of. Yes.
When did it expire? You had withdrawn that, right?
Yeah, it was up to only 2001. He did not file application for renewal. He filed it in the year 2023. Now the matter, there is a direction to transfer, he is open all the points. The secretary has renewed the permit from 2001 to 2006. 5 renewed. Section 81 of the motor vehicles. The renewal of permit within only for 5 period of 5 years. If the application is pending, if it has been filed within before expiry of 15 days, as per section 81, it is kept pending. Then it is something is different. Here, the permit was cancelled, that he did not challenge, that it remains as it is. That has been renewed for 5 consecutive years, for 2001 to 2002.
Whose writ petition was that earlier 1304 of 2024?
But 1304 of 2024, what he did. Right application available,
So his renewal has been allowed and matter was remitted back.
remain back. What the Honorable Court says, that without this one, the page
But
46.
this is rival claim, rival claim.
Right for past the act.
For so many years you were not, you withdrew your permit, right? For how many years you withdrew? You had withdrawn.
He withdrew process. And the legal order.
So he was running the,
But he did not run at all. 96 it was granted. 97 vehicle was made. Thereafter it was cancelled. That order also did not. He did not that only by filing this writ petition 2021-24, page 46. That you lordship can see
Yes.
there in the writ petition. Pass the order pass the second prayer. Pass the order pass the first responding. In serious subject number so and so 24/6/97. Writ petition filed in 24. And the third prayer is fourth prayer. Direct the response consider the renewal application. Permit is set aside. Permit was the card was not set aside. Define application for renewal and ask for a direction from this Honorable. This Honorable Court says, without expressing any opinion on merits, that matter is the respondent directed to consider the renewal application. All points are kept over. What the secretary in the next order, also see, page 50, that he says that my High Court has directed and then I am renewing it. The not at all consider any whether the permit was cancelled, permit was restored, or the cancelled order is satisfied by any appellate court, he did not consider the law. Secondly, after 28/9/2017 and 7/3/2019, schemes have been amended. The existing permits are saved, only those who are operating. The first amendment 14/2002, the second amendment.
what happened to that notification which you had challenged before the coordinate bench? What happened?
ಅದು ಮತ್ತೊಬ್ಬ 19 ಅಲ್ಲ ಅದರಲ್ಲಿ ಇಲ್ಲ ಇದು ಈ ಪರ್ಮಿಟ್ ಅದು ಪರ್ಮಿಟ್ ಇಲ್ಲ.
Just let them file their objections. You file their objections. List it immediately on Wednesday. Let them. Who takes notice for respondent number 1 and 2? CGP to accept notice for respondent number 1 and 2. You have entered KVF. Reference of counsel as filed KVF for respondent number 3. Kutige Ramesh, Learned Senior Counsel, appears for respondent number 3. Harish Bandari is directed to accept notice for respondent number 4. Petitioner counsel to serve the petition papers on the learned counsel appearing for respondent number 4. Others ella bandidiyala? Since when you are operating?
But 25 years, sir.
Formal judge observed, even before the petition was filed, that's said will be coming months. That's it.
Correct.
No, but this is the case. Observe nobody doesn't we are operating. No, operation is what they do. For the 20 years.
Prior to your operation of the services, who was operating the services?
We are operating.
Even he did not operate on any particular order.
We are not coming in the way of salvation.
That for this mercy is not necessary.
That's what is, no, you just clarify this.
No.
Both want to know who is.
So one minute. What is the position before the permission was granted to respondent number 3? What was the position? What was the position?
Let me make. The permission was granted to respondent number 3. It's an independent permit. My permit was granted in the year 1967. His permit is altogether different. 99. and he continues to operate even when I operate now. I'm not saying.
Does his business get affected in light of you being granted?
The permits are given for 5 years in the
No,
state.
how can you, what is your locus standi to challenge?
That's what the court says, that is.
I
What
just
would
find
you
that
say?
judgment is there.
What are the- We file our objections, Mr. Only to file the statement of objections by next date of hearing. This matter on, when do you want? Huh?
Yes.
When do you want?
21 I had some. 20th.
20,
23rd.
24th, 25th. Well, 25th is the day when we take this matters, right? In the preliminary hearing itself.
For petitioners, my lords.
What is this?
My lords, this is a petition pertaining to drawing up of electric lines, my lords. Petitioners being dissatisfied with the compensation granted by the court below.
Notice for respondent number 1 and 2.
One. Respondent number 1.
Who appears for this managing director, Kudgi Transmission Limited? Any standing counsel?
I'm not aware of that, my lords.
You take notice then. Issue
Please.
emergency notice to the respondent.
Please, my lords. Much obliged.
What is this, Mr. Abhijit?
Yeah, for temporary connection. They grant the temporary connection later on disconnect.
Why? On
Yeah.
what?
Or by.
Hello.
By which?
Why is it disconnected now? At whose request it is disconnected?
There said that layout is the unauthorized layout. That's the annex of the L3. Neighboring.
Let us direct somebody to take. Who takes notice?
Meantime, temporary connection.
Yaar ಹೇಳಿ? Who takes notice?
Number 2.
Yaro, who is the
This
counsel?
one, subdivision 4.
Are you standing counsel?
Senior. 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 From last 2 months.
Sri Devarajan is directed to accept notice for respondent number 1 and 2. Then counsel for the petitioner, submit that the petitioner is the absolute owner of the petition premises. And he has, after obtaining necessary permission from the authority, is putting up construction in the petition property and had obtained power connection from the jurisdiction Westcom office. Westcom. It is contended by the respondent number 2 by the impugned notice, by the impugned notice, the at annexure G and J1, the respondent number 2 has communicated that they would not grant temporary electricity connection to the new construction house. To new construction. the as on date, there is no connection
No
given.
connection.
When was the
That's what
connection?
was up.
When was the connection there? Till what time the connection
8/20/2020 connection was given.
was given?
Yes.
Till what period you
After
had
1 month, they disconnect.
the circumstances made up as the providing of electricity connection is the basic necessity of a citizen. The respondent respondent number 2 is directed to provide temporary electricity connection to the petition premises and the petitioner to continue to pay the consumption charges. Yes, Shubha? Yes, please.
Second term. Petitioner Pushparaj Associates is a registered partnership firm. Having company has 5 partners. 6 as of today. One of the partners, they all died during the validity of the license 2023-24. Meenakshi died on 6/1/2024. When the license was in force and the license was in the name of the partnership firm. Thereafter, the death was also intimated on 14/2/2024 within their own law of 45 days of the death. Subsequently, my lord, reconstituted partnership, everything is informed on the ground that perhaps without there being a proper order, the admitted partner, son, is disqualified under Rule 4B of the Sale of Indian and Foreign Liquor Rules. Abruptly, the license premises was closed. Then an application for renewal was also made. I want to kindly find the application for renewal. Because on the earlier occasion, it was stated that it is not paid, though the license fee is paid. Annexure M, page number 54. But they are not their own process of it is submitted at the level of the Inspector of Excise to avoid rush in the deputy commissioner of Excise, one in the several inspectors range wise. These applications, along with other particulars, and proof of having remitted the license fee is given to the Inspector of Excise. So it is dated 28/6/2024, in advance before the expiry of the earlier license as required by law. In turn, the Inspector of Excise prepared a checklist. Next page, another lecture around 10, page number 68. This checklist is in the name of the state emblem, Karnataka Sakara Abukari Ilake. This has been prepared for forwarding to the Deputy Commissioner of Excise for a favorable order, also required to be countersigned. Page number 62. Surprisingly, no signature of the officer concerned. It was returned to the, because why I have not submitted on the earlier occasion is there. On my indication is found that without further process it is returned. And on the previous occasion it is stated that the application is not made at all. But when the earlier petition was pending, at page number 68, annexure Q, on 16/8/2024, without any reference to the pending proceedings of the petition before its honorable court, though the respondents, all the respondents are party to the earlier, the Deputy Commissioner of Excise issues an endorsement intimating that the application renewal is not possible to be considered and that there is no scope for running the business. If I can read the order, my lord, the entire first page is the correspondence. ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಪುಷ್ಪರಾಜ್ ಅಸೋಸಿಯೇಟ್ಸ್ ರಿಪೋರ್ಟ್ ಮರುಕಳಿಸಿಯನ್ನ ಅದು ಜನರು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿರುವಂತೆ ನಿಮ್ಮ ಉಲ್ಲೇಖ 1ರ ಪತ್ರದ ಅರ್ಥ 19 ಪಾಲುದಾರಿಕೆ ಸಂಸ್ಥೆಯಲ್ಲಿ ಮೀನಾಕ್ಷಿ ಚೌಶೆಟ್ಟಿ, ಸಿದ್ದಲಿಂಗೇಶ ಚೌಶೆಟ್ಟಿ, ಜಿ.ವಿ. ಕೋಟಿ, ಪ್ರೇಮಾಜಿ ಕೋಟಿ, ಗೀತಾ ಎಸ್ ಚೌಶೆಟ್ಟಿ ಒಂದು 5 ಜನ ಹೊಂದಿದ್ದು ಸದೃಢ ಪಾಲುದಾರ ಪೈಕಿ ಒಬ್ಬರಾದ ಶ್ರೀಮತಿ ಮೀನಾಕ್ಷಿ ಚೌಶೆಟ್ಟಿ ಅವರು 6/1/24 ಬಸವರಾಜಿದ್ದಾರೆ. 17/2/26 ಇವತ್ತೇ ಗಮನಕ್ಕೆ ಬಂದಿರುತ್ತೆ. ತಡವಾಗಿ Limitation Act says 90 days. According to their unwritten procedure of the Excise Department, 45 days. Still they ತಡವಾಗಿ ಬಂದಿರುತ್ತದೆ. ಈ ಸಂಬಂಧ ಉಲ್ಲೇಖ 2ರ ಜ್ಞಾಪನ ಪತ್ರದ ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು ಮಡಿಕೇರಿ ವಲಯ ಮಡಿಕೇರಿಯಲ್ಲಿ ಪೈಕಿ ಒಬ್ಬರಾದ ಶ್ರೀಮತಿ ಮೀನಾಕ್ಷಿ ಚೌಶೆಟ್ಟಿ ಅವರು 6/1/24 ಮುಕ್ತರಾಗಿರುವುದಾಗಿ ಸಮುದ್ರದ್ವಾರ ತಿಳಿಸುವುದರಿಂದ ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮಕ್ಕಾಗಿ ವರದಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗುತ್ತದೆ. ನಂತರ ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು ಮಡಿಕೇರಿ ವಲಯ ಮಡಿಕೇರಿ ಅವರಿಗೆ ಇದನ್ನ 3ರ ತಿಳುವಳಿಕೆ ನೋಟಿಸನ್ನು 27/2/24 ನೀಡಿರುತ್ತಾರೆ. ಹಾಗೂ ಈ ಕಚೇರಿಯಿಂದ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸು 9/24 ಹಾಗೂ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೊಡಗುತ್ತಿಲ್ಲ ಮಡಿಕೇರಿಯವರ ಕಚೇರಿಯ ಸೋಲಿಸುವುದು ನೋಟಿಸ್. The Deputy Commissioner, though there is no violation of Excise law, a notice was got issued from the Deputy Commissioner of Excise, giving 3 days time to reply. However, my lord, to avoid all complication, it was opted for compounding and a 45,000 rupees compounding penalty was levied and credited. ಮುಂದುವರೆದು ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೊಡಗು ಜಿಲ್ಲೆ ಮಡಿಕೇರಿಯವರ ಆದೇಶದಿಂದ ಅವಧಿಯವರೆಗೆ ಪಾವತಿಗೆ ಸಲ್ಲಿಸಿದ ಕಾರಣ ಪಾವತಿದಾರರು ಕೋರ್ಟ್ ಮಧ್ಯೆ ಬರೋ ಸಮಾಜ 700 ರೂಪಾಯಿ ದಂಡ ವಿಧಿಸಲು ಆದೇಶಿಸಿದ್ದಾರೆ. ನಿಮ್ಮ ಪತ್ರದಲ್ಲಿ ಅಸೋಸಿಯೇಷನ್ ಅಪರಾಧ ಶ್ರೀಮತಿ ಚೌಶೆಟ್ಟಿಗೆ ಹೊಂದಿದ್ದ 30% ಪಾಲ್ಗೊಳ್ಳುವಿಕೆ ಇದೇ ಅನ್ವಯ ದಿವಂಗತ ಮೀನಾಕ್ಷಿ ಚೌಶೆಟ್ಟಿ ಮೊಮ್ಮಗನಾದ ಡೌನ್ ಸಿಂಡ್ರೋಮ್ ಇರುವ ಸಂಬಂಧ ಹೆಸರಿಗೆ ಬದಲಾವಣೆ ಮಾಡುವ ಮಾನ್ಯ ಅಬಕಾರಿ ಆಯುಕ್ತ ಮಾರ್ಗದರ್ಶನ ಕೋರಲಾಗಿದೆ. ಅವಶ್ಯಕ
217A, what does it describe?
217A provides for transfer of license. In the event of the death of the license, that is an individual license, not a corporate license. 17A provides for transfer of the legal heirs of the licensee in general condition.
What does the rule prescribe?
2 days, I read now.
What happened?
Individual license.
What happens to a partnership firm?
It is not partnership, but so long partnership is lapsed. On account of the reduction in the partnership, perhaps this honorable court has decided in the case of Shankar Wines, any outgoing partner's share goes beyond 50%. What happened was in the earlier occasions, these licenses are not transferable per se. People used to transfer by creating partnership and admitting the purchasing partner and the selling partner going out. So, to avoid Rule 17B, which provides the payment of transfer fee, the issue was decided by this honorable court. In the case of Shankar Wines, now they have amended also after that. In the event of the 50% of the share capitals of the outgoing partner Coming to an incoming partner, they have to pay Rule 17B, this transfer bill. Here, outgoing partner's share is only 30%. Even if that has to be applied, there is no 50%. Now, 70A will not apply for the reason that
See, when a person dies, now in a partnership, one of the partner has died.
Right.
Now, one of the legal heir wants to come as a partner of this firm. Now, that person, if is an unsound person, if it is not able to understand the consequences of the transaction, then he should be by a guardian as per CPC. Then a guardian should be appointed for the minor for conducting this
It's
partnership.
not a minor also.
Father is it. What is your contention now? Rule 4B. Ah. Person shall be disqualified.
Who being disqualified. That is, the issue has been decided by the Honorable Court. To become a partner, one should be competent to contract.
Photograph of. Now your ground for refusing to grant the renewal of license on the ground that this person is suffering from Down syndrome and he is not entitled to continue in the business. Now, how would they, because there are other partners. Ah. Ah. Ah.
Will not come in this case. It is a partnership business.
Then partnership under one person dies, it extinguishes. Then that right goes, then the
One
other
person
partner.
dies, more than two partners, partnership continues.
So that partnership continues. Why are you
The
including?
others will continue his share. Or one can admit, any number of persons can come in or go out. So long as it is less than two partners, it is a partnership continued. One should be competent to contract to become a partner. And he is
Whether a person suffering from Down syndrome,
decided by the Honorable Court.
Down syndrome can.
It is not a unsound mind. It is not in plan of insolvency. It is two things. One judgment is there in the Honorable Court. Yes. Person who is a vegetative condition. Supreme Court also said. If such persons are denied, they will be put on straight for begging. ತುಂಬಾ ಜನರಿಗೆ ಇಂಥ ಮಾತ್ರ ಆಗ್ತಾ ಇದೆ ಅನ್ಫಾರ್ಚುನೇಟ್ಲಿ ಅವ್ರು ರೆಸ್ಟೇಟ್ಮೆಂಟ್ ತೋರ್ಸಕ್ಕಾಗಲ್ಲ ಈಗ 17 ಎಲ್ಲಿ ಬರುತ್ತೆ ಹೇಳ್ಬೇಕು ಈಸ್ ಡೆಪ್ಟಿ ಕಮಿಷನರ್ ಕ್ಲಿಯರ್ಲಿ ಪನಿಶ್ಡ್ playing with human rights.
If the person is suffering from some Down syndrome or any incapacity, then there is a provision in civil procedure that then a guardian has to be appointed on his behalf because he would not understand the consequences.
An individual case,
Not even in an individual case, even in a partnership, if you have to impede that particular person as a partner, let it be, let the other partners, you have to impede those partners. You cannot impede a person of an unsound mind or a mentally detached. Then guardian, through a guardian, he cannot have in an independent way. Because he will not understand the consequences.
he will not.
No, he will not understand. It's not a senior counsel's word.
Go far. This is the case wherein he was holding a license. He was holding a license. Unfortunately, fell him. That is stroke. So, when the such a condition that he became totally immobile. A vegetative condition is a wood, living wood. Power of attorney was executed in favor of his wife when he was in a condition. The Excise department put up the same kind of trouble. For about 2 to 3 years, the family had to suffer without license. The wife is Timothy Sonalata. This on the court, after which he was earlier on 2-3 occasions of that, he was referred to remands, he was referred to other neurology department everywhere. It was certified that he is not of unsound mind. What I require under Rule 4B is only 2 things. Should not be of unsound mind and should not be an insolvent. Means, if a person is competent to contract, he is entitled for the millions. Why is that?
Correct. In this matter, he had already executed a power of attorney. So there is somebody who is protecting his
They
interest.
are not recognized.
It is protected. Now, even if you say that you want to come on record as a partner of the partnership firm, his right would not be protected until he has been given by a guardian.
The individual person, licensee, who became immobile. Well, here in this
It
case,
is more in trouble for you, not for the respondent, because the person whom you are trying to say is a legal heir, he is not properly understanding the consequences. So take a guardian for the unsound.
is, what happens, it's a partnership.
No, as a partner, you cannot. The law does not permit for this individual capacity to be a partner of that firm. It doesn't.
He is competent to contract. He is competent to contract. That's why my entire submission is on that. Excise law does not speak of all this.
We are not saying about excise. Now we are saying about the partnership.
General law, of
Partnership.
contract or a partnership, it means
Can
incapable of a
an
partnership.
can an unsound person be a
It
partner?
is not a unsound person.
Then you,
If it's an unsound
then
person, who must be a track?
there is a certificate produced.
No.
It is produced. It is produced.
Disability is different. Supreme Court
The
can say,
disability is mental disability, not that disability. Not physical. See, it is harmful for you more than anybody else, not the others. You have to protect the interest of that. Yes. Then any unsound person, anybody will come on record. There will be all so many things. Let them add that. Now, what is the order now passed? You said you will not consider.
intellectual disability. Intellectual disability is not an unsound mind. There are, I have seen, but there are so many.
We have not rejected.
Yeah, so element is all mind. I would advise my party to think about it. They should be more favorable to Genealogical.
But you should have somebody. You should have somebody who will protect his interest. The Act does not, the CPC does not provide an unsound person to enter into a partnership firm. Alva. Alva. So this is that principle has to be applied here. Basic principle, Alva.
Yeah, in the event of
In the
certain
event.
things, they have one partner cannot receive other.
Correct.
They need a gap.
Everything doesn't go on fate and everything. Sometimes. Oh, you see, at this point of time, you may say that it is perfect, but you never know when what happens. So that is the reason the court is telling you.
They wanted the person want if he does not have anything, any means.
Do it by a guardian for that. Guardian.
That means if I have to go to the court for appointment as a guardian, through guardian, in this only, the partnership only will provide.
Yes, you have to provide for that.
Otherwise, to appoint a guardian under the natural guardian. Mother is not there. Father is there.
A father is the natural guardian is the father.
Grandmother is not there. Father is there. Father is not there.
That is the thing you have to do. Then I think this will serve.
My God's information. I have to manage.
No, because this is in the interest of that person who is.
Ultimately, what I say or what other side says, we talk.
Yes, that is why the interest of the child. We will not know.
Not so many.
We will not know what are the consequences.
Not that different. It's not so many.
So somebody who is in the interest of that child should be made as a guardian for that and then enter into a partnership. Otherwise, you cannot enter into a partnership.
Here also, one of the very top ranking senior university son of a school was run in his name because the father was so comfortable here and now. A school was run to educate a disability school. That should be the spirit, not denying everything and
No, not denying, it is in the interest of his.
But definitely these officers who do this kind of job will have to be punished as give a ground to my law to.
Please. Please. Now what we will do now in this. Wednesday, at request of the petitioner counsel. So you just examine that aspect.
Your license fee is paid. Nothing is going to happen if about 10 days time like the business is saying. Let them review subject to the further hearing further result. Because the license.
In the event nothing happens on Wednesday, we will think of that interview. Wednesday.
There are some other borrowings will be there. They will be after these people.
Yes, we understand that. See, partner of an unsound person. If he is not an unsound, it is for his interest. You may only for the temporary purpose. But this is a temporary phase for seeking for a license now by the partnership. But the consequences are more because an unsound child or a person who is not able to understand the consequence is trying to be implemented in the partnership form. So the long run, it will be affecting the interest of that child. You verify. Just look into that also. On 18. Yeah. Yes. Yes. Have you received this?
No.
This statement of opposition, just plain statement and reply.
Had a license in form CL9 in respect of a place in Karnataka town. In Davangere district.
Yes.
We located a new place in the same town and made an application for shifting. By considering the same, and after examining it has required under Rule 23. The Karnataka Excise, license of development road. The Deputy Commissioner of Excise offered an order on 29/1/2024. And declared the reconsidered order, page number 14. Respondent number 4, who claims to be a press reporter, Mr. Manoj Shah. Press reporter. files an objection. And thereafter, he had filed an objection before the DC. He prefers an appeal under section 61(2) of the Karnataka Excise Act before the Excise Commissioner. The Excise Commissioner, after hearing the matter, my lord, passes an order on 13/6/2024, allowing the appeal in part and remanding the matter to the Deputy Commissioner once again to decide the issue. Whereas page number 26 is the order. The appeal is partly allowed. The impugned order bearing number so-and-so 2029 all 2020 is set aside. The appeal is remanded back to the first respondent to pass appropriate order in accordance with the after giving opportunity to the appellant and to all the concerned. In the meanwhile, what happened was that under Annexure C on 27/6/2024, the respondent number 2 in that case and the respondent number 3 hearing grants the license by way of renewal to the same place. That is dated number 27 on 27/6/2024. The order of the Excise Commissioner is 13/6/2024. After the Commissioner passes an order in the open court pronouncement on 27/6/2024, the license has been renewed.
Yes.
Surprisingly, without further notice, as director of the Excise Commissioner, the Annexure D, page number 31, dated 5/7/2024, the Deputy Commissioner of Excise directs the closure of the shop, running the licensing shop. My lord, kindly say, page number 32. ಆದ್ದರಿಂದ ಉಲ್ಲೇಖ 3ರಲ್ಲಿ ಮಾನ್ಯ ಅಬಕಾರಿ ಆಯುಕ್ತರು ಬೆಂಗಳೂರವರು ಅಪೀಲ್ ಆದೇಶ ಸೂಚಿಸಿರುವಾಗ ಲಕ್ಷ್ಮೀ ಮಂಜುನಾಥ ಡಿ ಭರಮಪ್ಪ ಇವರಿಗೆ ಸೇರಿದ ಮೂನ್ಸ್ಟಾರ್ ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ದೇವನಾಯಕನಹಳ್ಳಿ ಹೊನ್ನಾಳಿ ಇವರ ಸನ್ನದನ್ನು ತಕ್ಷಣದಿಂದ ಜಾರಿಗೆ ಬರುವಂತೆ ಹಾಗೂ ಮುಂದಿನ ಆದೇಶದವರೆಗೆ ಸನ್ನದು ಬಾಗಿಲು ಮುಚ್ಚಿಸಲು ಅಬಕಾರಿ ಹೊನ್ನಾಳಿ ವಲಯ ಹೊನ್ನಾಳಿ ಸೂಚಿಸಿದೆ. But what happened was this was yes, my lord, you kindly see the above portion of the Excise Commission of the appeal is partly allowed. The impugned order bearing number so-and-so dated 29/22 is certified. The appeal is remanded back to the appropriate order in accordance with the after giving an opportunity. Instead of hearing it on merits, giving opportunity, the Deputy Commissioner of Excise directs the closure of the meeting. Was questioned in the petition before 2004.
Which was question?
This order of the Deputy Commissioner of Excise closing the shop. We have no grievance with the order of the Commissioner. We will not. That's very out. The closing, one slogan in the Excise Department is Bangladesh should have said. Annexure 37 of the petition report to the judgment is on the court made. On that order of the Excise Commissioner, Deputy Commissioner of Excise, considered order, page number 51 is the order of the adversary reading following order. The repetition is allowed. The order dated 13/6/24 passed by the appellate authority, that's of the Commissioner of Excise, on sequential action dated 5/7/2024 passed by the Deputy Commissioner of Excise. Implementing the order of the appellate authority also stands fast. The matter is remitted back to the appellate authority to consider the matter afresh after according an opportunity of viewing the petitioner. Since both parties are represented by the Remand counsel, I direct them to appear before the appellate authority 25/7/2024 at 3 p.m. before the Commissioner of Excise appellate authority to receive any notice. The appellate authority shall consider so and so. Thereafter, the appellate authority considers. And then an order on page 53 Annexure H. Unfortunately, my lord, I know after finding the reply, I understand that there is a detailed order. And there's also no received the copy. But what is supplied to the petitioner is this Annexure H. Any operative portion is there. Appeal is partly allowed. The interim order bearing number so and so dated 29/2022 is set aside. Appeal is remanded back to the respondent to pass appropriate order in accordance with law after giving an opportunity of being heard to the applicant and to all the concerned parties.
Why once more for opportunity?
Because the honorable court directed the Excise Commissioner here also. He made and directed back. What happened was thereafter, it was open for the, I did not question this order of the Excise Commissioner also. It was open for the Deputy Commissioner of Excise. Consider the matter on merit after hearing both the parties. This order is dated 5/9/2024. Around the time dated 24. Order of the Excise Commissioner 5/9/2024.
6/9, no?
No, 6/9 is missing. 5/9/2024, Excise Commissioner
Yes,
passes
yes,
order in Bangalore.
And who
Very
passed?
next day, 6/9. The Deputy Commissioner of Excise, Downhill District. They are aware that government department takes years after cutting down to everything. Very next day, I do not know whether he received the copy of the order or whatever it is, or he was able to read the order. He passes an order like the earlier case, which has been set aside by this honorable court in the report. Now, my lord, page number 57. ಆದ್ದರಿಂದ ಉಲ್ಲೇಖ 3ರ ದಿನಾಂಕ 5/9/24 ಮಾನ್ಯ ಸಭಾಯ ಆಯುಕ್ತರು ಅಪೀಲ್ ಆದೇಶದಲ್ಲಿ ಸೂಚಿಸಿರುವಂತೆ ಎಸ್.ಪಿ. ಮಂಜುನಾಥ ಧರ್ಮಪ್ಪ ಇವರಿಗೆ ಸೇರಿದ 3 ಬಾರ್ ಅಂಡ್ ರೆಸ್ಟೋರೆಂಟ್ ನಿರ್ಣಾಯಕಗಳಿಗೆ ಅವಮಾನಪಟ್ಟು ಇವರ ಧರ್ಮವನ್ನು ತಕ್ಷಣದಲ್ಲಿ ಜಾರಿಗೆ ಮಾಡುವಂತ ಹಾಗೂ ಇಂದಿನ ಆದೇಶದಲ್ಲಿ ಬಾಗಿಲು ಮುಟ್ಟಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. By just like the earlier order which has been set there, I now may not come into the position of law. This order has to repeat continuous. I will continue except any one of the sentence result. There is no other place that can be directed to this.
What was the hurry for the deputy?
I don't want to.
What was the hurry for the deputy commissioner to pass an order? When the matter was remanded for the second time, what was the hurry for the deputy commissioner to pass a closure order? What was the hurry? There is an order of remand. Matter has to be reheard. Correct. There was there. Let us tell you where are the shops located earlier. See, this is not the first time. Third time. Correct. Correct. The matter is remanded for fresh consideration. When the matter was pending consideration before the respondent number 1, what was the necessity for the commissioner to pass this order? By whom? By this person, Malaysia. So you do everything on the pretext of this. How long? Yes. No, see, your role is very limited now in this one. Your role is limited because the matter is already remanded for the first consideration. So we'll stay this order. You will say that. We'll take that matter. We'll hear you leisurely.
Order of shifting that initially permitted me to shift the license of whether
Okay.
So that was shifting goal.
Correct. Matter was remitted back to the.
We
We are not going to hear all that. Then why was the remand necessary? You should have allowed it. You should have allowed it. If this was the impugned order to be passed by the deputy commissioner, why was a necessity to remand the matter? He would have straight away allowed the appeal itself, saying that they need not establish the stop at a particular place. Is it not? Why was it to be remanded? Then why was it to be remanded? It would have. When he sets, when he set aside the order of the first respondent, then he remands the matter. Then the deputy commissioner passes an order of closure. What was the necessity for remanding the matter? He should have said, we will hear this appeal on merits before the excise commissioner and will pass orders. What was the necessity for him? Entire order is not furnished to them. If this is the attitude of the deputy commissioner, we'll call him to be present before the court. Does he take into consideration all the objections? Huh. Supply of the copy is the impugned, the relevant portion of the order. Just tell us, Mr. Counsel, when a matter is remitted back, what is the order to be passed by the respondent number one? He has to rehear you. He has to rehear you and pass appropriate orders. Also hear the petitioners. Is it not? Is it not, Mr. Counsel? Then what was the necessity for the deputy commissioner to pass this order? If it is your grievance, you were not. Matter was remitted. He would have gone and made all your submission. After hearing them, the order should have been passed. This order itself is not. Please. Hey. So you assume this commissioner can do anything. Once the order is set aside, now I'll order for a closure. Is it appropriate? When the matter is still pending before the respondent number one. The matter is pending before the respondent number one, right?
That's what I'm trying to make. This is the consequential order of an order passed by the commissioner.
This is how they play.
Pending further consideration. For identical situation, the laws are considered. Statement. Very not, commissioner's order was implemented, and that was questioned before Milord said, going up.
Correct. Then the appeal was pending. What was the necessity for him to pass this order? Just tell us this.
Appeal ended.
Huh? Correct. It is for pending. Well, it is for consideration, right? There is no cancellation of that order. There is no cancellation of order. Is there any cancellation of the order?
After you go to another place, after the hearing.
Once the shifting order goes, what happens? Consequences. Either you have to go back or.
Let me make clear. If an order is set aside, then according to you, the shifting is cancelled. According to you. If shifting is cancelled, why was there a remand necessary? Why was a remand necessary? When you are being given a favorable order, why was a remand necessary? Do you understand? Why was a remand necessary? There is no final order. There is no final adjudication. Until a final adjudication takes place, how can you pass this order? Mr. Deputy Commissioner has to tell us. No, I hope this court has made it clear as to what this court is going to do. Correct. Why was a remand made then? Correct. So you can pass any orders. Deputy Commissioner can pass any orders when the matter is pending. See, he has not given any opinion here. He just decides the order, tells the court, tells the respondent number one to reconsider their application after giving an opportunity to you. Will that give a right to the Deputy Commissioner to cancel itself?
we have to consider this application for shifting afresh.
Shifting afresh is pending consideration.
Yeah, that one has to be closed.
License is removed to the present place.
That is not proper. We'll stay the impugned order. We'll hear you leisurely. Correct. When was this order passed? When was the order of respondent number 1 passed? It was an order in his favor, right?
Page number 17.
When was it passed? 5/9. 13/6. First order.
Order 29(1) to allow my application. Same officer.
Yes, it was allowed, right? What happened after that?
I challenge him.
What was happening during that period? The shop was running, right? It was running, right? You can tell, you can tell. Then suddenly you close that shop. Let them consider, you consider and pass orders. If that is in an objectional place, you immediately pass an order. Respondent number 1 should pass an order, not in this manner. You pass appropriate orders, but this orders we will keep. Closure under what is what happened? He was operating, right? He was operating. He was operating. He files an objections. He comes before the court saying that he is not being heard. Matter is remanded. He comes before this court. Petitioner comes before this court. Order is set aside. Then again an order, similar order is passed by the Excise Commissioner, or set aside the order, and then again remits the matter. Then he should have passed an order before the Excise Commissioner should have passed an order without setting aside the order of respondent number 1. Is it not? If that would have been done by him, this all would not have come to light.
The same number is in your instrumental court by allowing the secretary on the short question that was not heard in the that the incorrect submission that he challenged even appeal order saying that I was not heard in that by very look at the order pass very look at page number notes. Page number 38. Very look at page number 38.
The same order was passed, same order was challenged before this court, and that order has been set aside. So respondent number 1 has to consider, is it not? What happened after the order in the writ petition?
The commission itself was set aside.
That is what this is there.
Here also, appeal was ordered by the commissioner. Here after the deputy passed an order closed. They came before this honorable court challenging very appeal order as well as a consequential order as passed now.
Now what has happened here?
This honorable court set aside the original order passed by the commissioner himself on the ground that they were not heard in the matter by the commissioner. And consequently, NDC note that that's what order portion is. Then you get this. So then it comes to page number 51. They said we are not challenged, they are specifically challenged. The order is showing to pass by updated for the commissioner and the consequence.
What is that 5/7/2024 order?
Consequent order.
What is that consequential order?
Closure order.
Correct.
So
Was it permitted for you to do that?
Send them back to the commissioner, so direction to the commissioner to hear the matter of which can pass appropriate orders.
Correct.
So accordingly, commissioner.
And what does the Excise Commissioner do now? What does he do now? What is the consequence of that?
My submission is on the shifting order, those he cannot operate with the.
So that is what the Deputy Commissioner has done now. So then we'll dispose of this appeal. Yes.
And submission, legal aspect.
We'll set aside the order of respondent number, that is the Deputy Commissioner at Annexure J. That is all we are saying, right? Even if an interim order is granted, would be the same, or if you set aside the order at Annexure J, would be the same.
See, the result renewed for the current year, it is valid, page number 57. If it has to be closed, it should be suspended, withdrawn or cancelled by the Deputy Commissioner of the district, not the Deputy Commissioner of Excise. Under section 29 and 30. That is not done, once they pass the only
now-
reason is in the present order they are afraid of. And the purpose of this order.
He is challenging only the order at Annexure J. When the matter was remitted back to the respondent number 1, what was the necessity for the Deputy Commissioner to pass this?
First
So
question,
we'll set aside that order, direct the matter, be remitted back to the respondent number 1. Let the respondent number 1 consider the application, consider respondent.
last observation. Because same observation was found by honorable. Remand ಮಾಡಿದ್ರೆ commissioner remand ಮಾಡಿದ್ರೆ
Not so. It's the order. Unless it's the appeal order of the law, I have not been served with the supervisory.
Now the matter has to go to before whom? The Excise Commissioner? Excise Commissioner. Deputy Commissioner. Now this Annexure H is the order passed by the Excise Commissioner. Respondent number 1 now, right? So respondent number 2 is the, yes, we all do that. We will just say that we'll set aside the order, go before the respondent number 2 and let them pass appropriate orders before
on merits of the case.
on merits.
Order should.
We'll set aside this order. That's it. Whatever consequence it will appear, it will be there. The petitioner has called in question. Ah,
One of these cases,
ah.
the heavy cost should go, not for me, at least for some state department only. They are ಮಾಡ್ತಾರೆ, ಯಾವ ಕೇಸಲ್ಲಿ ಅದೇ. Mostly, and
Ultimately, we want to do something for the petitioners who are coming before the court.
because they are working on.
But not in this way. Not in this way. Definitely not in this. Now look at the Deputy Commissioner is so interested in doing it immediately, immediate work. Hello? Very prompt. The petitioner has called in question the order. Memorandum or order other?
Order, captioned as memorandum.
Order captioned as memorandum dated 6/9/2024. Passed by the respondent number 2. Deputy Commissioner of Excise. Excise. Yes. And at Annexure J. At Annexure J. Heard Shri G.K. Bhatt, Learned Senior Counsel for the petitioner. You appear for whom? Respondent number? Learned SCGP out for respondent number 1 to 3. And Shri Mohan Bhatt for the respondent number 4. The brief facts are that the petitioner was a licensee in form CL9, made an application to the second respondent on 19/1/2024 and sought for permission to shift the business. The respondent number 2, the competent authority, Deputy Commissioner of Excise, made an order on 29/1/2024, permitting the petitioner to shift, permitted the shifting of the business, which was carried out by the petitioner. After the lapse of 3 months, the respondent number 4 After the absence of the body, the respondent number 4 preferred an appeal before the first respondent. The first respondent passed an order allowing the appeal in part and remitting the matter to the second respondent. It has been stated that the second respondent had renewed the license for the current year in respect of the shifted place. As the petitioner was not afforded an opportunity in the appeal referred by the respondent number 4, the petitioner approached this court in WP 18327 of 2024. And this court, by the impugned order, this court, by the order dated 12/7/2024, directed the first respondent to consider the matter afresh in accordance with him. The relevant portion of the order reads as under. Page 50, 51. Pursuant to the order of remand passed by this court, the first respondent, Excise Commissioner, allowed the appeal in part, filed by the respondent number 4 in part, and set aside the order of the respondent number 2, and the matter was remitted back to the respondent number 2 to pass appropriate orders in accordance with law. The order of the appellate authority was passed on 5/9/2024. The Deputy Commissioner of Excise on 6/9/2024 abruptly passed an order directing the closure of the licensed business of the petition. The Deputy Commissioner of Excise, respondent number 2, failed to consider that the respondent number 1 had remitted the matter to the respondent number 2, Deputy Commissioner of Excise, to consider the matter afresh. And when the matter was pending consideration, the impugned order of closure is being directed by the respondent number 2, making this court to interfere and set aside the order passed at Annexure J. The first respondent, having directed the respondent to pass appropriate orders after affording opportunity of being heard, could not have passed the impugned order at Annexure J without notice or hearing the petitioner. In the said circumstances, this court passed the following order. Writ petition is announced. The impugned order at Annexure J dated 6/9/2024. The memorandum bar order. It's an enforceable order, right? You ಏನಾರೆ title ಕೊಡಿ. The main order is to implement that order. So you may give any head for that. You may title it in any way. Notice ಅಂತ ಹೇಳ್ಬೋದು, but the order would be something else. Order bar memorandum dated 6/9/2024 is hereby passed. Matter is remitted back to the respondent number 2. Matter hereby quashed. Respondent number 2 is directed to consider the application of the petitioner in accordance with law within an outer span of 15 days from the date of release of this order.
Objection. Application is allowed under Annexure A.
Consider as per Annexure H The remand alva, as per annexure. In terms of the order at annexure, yes. In terms of the order at annexure, yes. You communicate the order here. 15 days from the date of release of this order. Mr.
Section is there.
Immediately, kindly intimate. A consent officer must be there before the court. Who intimate him. Please, Mr. Prakash, what happened?
My lord, I am appearing for appellate.
Is that very matter?
Yes, my lord, that is a
Wait,
that is a different matter. My lord, here it is an appeal filed by plaintiff. My lord, may I make one submission? My lord, today I have some difficulty. I had an injury to my left eye. My lord, it is difficult for me to read and my lord, I want
he's
10
not
days.
well. He's got an injury. SV Prakash, Tenant counsel appears through video conference and submits that he is suffered an injury to his left eye and is unable to make any submission of the present matter. At request, list this matter. When do you want, Mr. Prakash?
10 days. 10 days.
List this matter on 26th.
Blessed. I'm highly blessed.
Yes, Mr. Nagesh, what happened? We will not dispose of. Let them get the fruits of the decree at least during her lifetime. Once she gets a share, others will be at least taking care of her. 1 minute. Madam, Hindu Succession Act. Section 8 would apply here, right? Huh? Last one. Where is the genealogy?
Page number 54. Page number
54 nalidya. 104 or 54? It's not here. Genealogy ellide. Paper book idya. Along with the appeal paper.
Relationship is not
Namke bekala. We have to know what is the relationship. How is it be done? Notes again. Just tell the relationship. Who is the propositors?
for the legal ends of KGC.
So one
Respondent
KV.
is the mother of KGC.
So this Lakshmama is the respondent here.
Yes, sir.
And who is the daughter-in-law?
Daughter-in-law is the first.
Or Hesareno?
Umadevi.
She is the Sridhar Murthy's wife. Plaintiff number 1 now. Plaintiff number 1.
Dependent number 1.
Dependent number 1 and dependent number 2 is her daughter and son, Lakshmi Shah. And she is the plaintiff. When did Sridhar Murthy die?
Sridhar Murthy died
1803, 2000.
2000.
Assailing the legality and correctness of the concurrent findings of facts recorded by the courts below. The defendants 1 and 2 are before this court, the regular second appeal. Parties herein are referred to as per the rank before the trial court for the sake of convenience. Plaintiff instituted suit for partition and separate possession of her 1/3 share in the suit scheduled properties. The plaintiff is the wife of 1 KV Govindaya. They had 5 daughters and a son. The son of the plaintiff and KV Govindaya died on 18/3/2012 after the partition had been effected between the plaintiff and her children on death of KV Govindaya on 21/5/2007. The plaintiff contended that as per the partition deed, survey number 231/4 measuring 1 acre 36 gunta has been allotted to share of KG Sridhar Murthy, the son of the plaintiff. And on his death, the plaintiff and defendant number 1 and 2, being the class 1 heirs, are entitled for share in the suit schedule property, which was fallen to the share of Sridhar Murthy. She did not file her objections. On notice, the defendants appeared and filed their written statement, admitting the relationship of the plaintiff and the defendants. However, the defendant contended that as per the partition, survey number 231/4 measuring 1 acre 37 gunta suit property bracket money was allotted to the share of KG Sridhar Murthy. And after his death, the defendants are in possession of the suit property, and the plaintiff has no right to seek for partition. The trial court, on basis of the pleadings, framed the following issues, page number 29. In order to substantiate their claim, the plaintiff examined herself as PW1 and got marked documents at Exhibit 3:1 to 3:2. On the other hand, the defendant number 1 examined herself as PW1 and marked documents at Exhibit D1 to D2. The trial court, on the basis of the pleadings, oral and documentary evidence, arrived at a conclusion that the plaintiff has proved that he and the defendant are the joint family members, and the suit schedule property is the joint family property, and the plaintiff being the class 1 heirs as envisaged under Section 8 of the Hindu Succession Act 1956 is entitled for equal share with that of defendants 1 and 2, and decreed the suit of the plaintiff allotting 1/3 share to the plaintiff and defendants 1 and 2 to be entitled for 1/3 share each in the suit. In fact, she should receive half, because the as a branch it will be defendants 1 and 2 one day. Yes. Aggrieved, the defendants preferred appeal before the first appellate court. The first appellate court, while reappreciating and reconsidering the entire oral and documentary evidence, concurred with the judgment and decree of the trial. Heard the learned counsel agreed with the present appeal by the heard the learned counsel for the appellant and the learned counsel appearing for the respondent and produced the judgment and decree of the courts below, including the records. The family pedigree is as under: KV Govindaya, or Lakshmama MNT, Ananta Devi, Girijamma, Padma, KG Kamala Devi, KG Indramma, KG Sridhar Murthy, only dead and happily Sridhar Murthy, K. Uma Devi, dependent number 1. Lakshmi Shah, dependent number 2. The suit property was allotted to the share of Sridhar Murthy, the husband of dependent number 1 and father of dependent number 2. The said Sridhar Murthy died on 18/3/2012, leaving behind him his wife and son and the plaintiff mother. As per section 8 of the Hindu Succession Act and the Act for Short Act, the property of a male Hindu dying intestate shall devolve according to the provisions. Firstly, upon the heirs being the relatives specified in class 1. As per class 1, the son, class 1, son, daughter, widow, mother, son of predeceased son, daughter, it's at the page 15. And as such, the plaintiff being the mother is the class 1 heir of deceased Sridhar Murthy. And on his death, the plaintiff is entitled for share along with the other legal heirs of Sridhar Murthy, who are the dependents 1 and 2. It is also brought to the notice of this court that the husband of dependent number 1 was working as a teacher in a government school. And on compassionate appointment, the dependent number 1, the daughter-in-law of the plaintiff, is been given employment. The trial court and the first appellate court rightly arrived at a conclusion that the plaintiff is entitled for 1/3 share in the suit property. The manner in which the courts below have assessed the entire oral and documentary evidence, this court is of the considered view that the same does not warrant any interference by this court under section 100, and no substantial question of law arises for consideration in the present appeal. And this court passed the following manner. The regular second appeal is hereby allowed. The impugned order, the impugned judgment and decree of the courts below stands confirmed. Dismissed. Dismissed. Allowed anta helda. Oh, sorry. Dismissed. Sorry. Dismiss anta barutade. Happened. Awaiting court notice in respect of 1B, na? So we had to issue notice to them, right? Await service of notice in respect of R1B. So when there is a death, we can't do anything. Retirement. Yes, what is this? Await, na? Await, na? What, na? It's not seen. So it has to be served. Yes, at request of the appellant counsel, a week's time is granted to do the needful in respect of unserved respondent number 1. Non-serving of the copy to the caveator under.
Respondent number 1, RTA has kept this permit in the meeting dated 18/9/2020.
18
9/2024, on Wednesday, this permit has been kept in the meeting of the Tribunal.
ಈಗ ಏನಾಗತ್ತೆ ಈಗ ಮೀಟಿಂಗ್
Some part is possible to be an executive channel, that also.
Third on the vehicle has to stop. The vehicle is already stopped.
My submission, Madam,
let us understand the thing. ಯಾರು ನೀವು who are you
I am for the petition.
correct what is your grievance
You
your operating services
may kindly see,
from when you are operating services
20 years. Yes, you may kindly see Annexure D. Yes,
Annexure D ಈಗ as on today who is operating the
I
services
am operating petition. Moreover, the Tribunal has passed the order after the expiry of the permit. The permit was expired on 3/7/2023. The Tribunal passed the order on 7/11/2023. My renewal has been further renewed.
one ನಿಮಿಷ when was it granted 3 first order
First order annexure A may kindly correspond. This is the order passed by the authority renewing my permit. It was valid up to 3/7/2023.
3/7/2023
Yes, madam.
when first permit for
That is annexure C may kindly be correspond. 36 page.
ನೀವು ಡೇಟ್ ವೈಸ್ ಹೇಳ್ಕೊತ ಹೋಗಿ ಆಮೇಲೆ ಹೇಳಿ ಹೇಳಿ
3/7/2023 annexure C permit was expired during the pendency of the revisions made by the KSRTC or 3 and 4. This Tribunal passed the order on 7/11/2023. I filed the further renewal application and obtained further renewal annexure D.
you were granted renewal on 7/11/2023
Yes,
where is
they have
that order?
questioned that previous period of renewal.
where is that order
That is annexure A.
Mr. A is your
That is
renewal
expired.
it's expired
But after expiry, Tribunal has passed the order to set aside that order. Now I am operating with annexure D. It stays now. This renewal they have not challenged.
no this is when was this order passed 26 2
That is subsequent renewal.
8 November.
You may kindly peruse the Tribunal order. I am not disputing. You may kindly peruse the Tribunal order annexure H page 43.
Will also give that.
What means I submit my let me submit. Submit.
ನಮ್ಗೆ ಫ್ಯಾಕ್ಟ್ಸ್ ಗೊತ್ತಾದ್ರೆ we can
That I am submitting. Times. That I am submitting.
ಹೇಳಿ
Annexure H, which I have challenged before this court, the petition. That is annexure H page 43. That is order dated 8/11/2023. Revision filed by the rival operator at KSRTC. And the Tribunal passes the order. You may kindly peruse the order portion, page 56.
page 56 the impugned common order
Both the revision petitions filed under section 90 of the Act under rules 88 are hereby allowed. The impugned common order dated 19/4/2022, that is annexure A, passed by RTH to Nursing number 4 in permit number 19/98 and it is valid up to 3/7/2003. That is actually 23 plus type of error is renewal.
annexure A ಗೆ ಬನ್ನಿ annexure A
Yes, madam. Yes.
because 3/7/2003
That is the cancellation order. The operative portion is the third portion of the same proceedings. They have renewed up to 2023. That is the endorsement issue annexure C.
3/7/2003 no 3/7/2023 now
What submission, madam? 2% is the cancellation of the RTA proceeding matter. In the meeting dated 19/4/2022, the authority considered my 3 renewal application and granted the 3 renewals and annexure C.
so there are 2 orders now 3/7/2003 and 2/7
No. That is remanded. What the 3/7/2003 remanded by the Tribunal. And Annexure C is the endorsement issued by the authority for the valid period 2003-23. And now the Tribunal has passed the order on 8/11/2023.
During the pendency of this review petition, RP, was your, was
No
were you,
stay was granted. I am operating since from the endorsement that is dated.
were you running the, were running?
Yes, sir. 34/2022. In order is passed, I was running, but the permit was expired on 3/7/2023 itself. Order was passed on 8/11/2023. Further renewal I also obtained on 26/2/2022. That is Annexure D.
Why there is so much inconsistent orders being passed? Allah, why is such an inconsistent?
One more para I will read out, madam.
Mr. Bhandar, see, when there is an order of renewal to the petitioner, and why does the review petition or the appellate authority by passes a contrary order?
Not this.
Allah, let us understand one thing. Mr. Bhandari ಅವರೇ, review petition ಹಾಕ್ತಾರೆ. You have filed that review petitions, right? Granting of renewal license in his favor. He was operating that services.
Yes,
Correct. If-
He has not entered the appearance, madam. That KSRTC have no objection.
Mr. Counsel, I'm asking Mr. Bhandari.
Yes.
Let us understand one thing. There is a renewal license in his favor in the year 2003. Allah, one ನಿಮಿಷ. Let us, ನೀವು date ಹೇಳಿ ಆಮೇಲೆ. There is a renewal license in his favor. You challenge that order of renewal of license. In that interregnum, he was operating the services. And I thought this is the understanding as per the submission, because there was no stay in the review petition. Renewal license was there. And after the review petition was allowed, there is again a renewal of license for the petitioner. See, 26/2/2020. Why such inconsistent orders?
Annexure D.
Allah, why is there such inconsistent orders ಅಂತ ಕೇಳೋದು?
all the possible
Correct, huh? ಅಲ್ಲ, ಒಂದ್ ನಿಮಿಷ. You had challenged this order. Review petition ಹಾಕಿದ್ರಾ ನೀವು? Challenging what renewal?
Annexure A.
So 2003 to 2023, you had challenged.
ಎಕ್ಸ್ಪೈರ್ ಆಗಿದೆ
ನಾನಲ್ಲ, ಹೌದು. ನಾನಲ್ಲ, ನಾನು ಮಾತಾಡಿಲ್ಲ.
2003 ಎಕ್ಸ್ಪೈರ್ ಆದ ಪರ್ಮಿಟ್ ಅನ್ನ 2019 ಅಲ್ಲಿ ರಿನ್ಯೂವಲ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋದು.
ಆಯ್ತು.
So he was not operating in 2019 as of the date of introduction. Even after that, that application was considered in 2021. The application was considered by compounding fees ಆಗಿರೋದಿಲ್ಲ. ಇಪ್ಪತ್ತು compounding fees ಆಗಿ 3 ದಿನಗಳನ್ನು ಒಂದೇ ಸೆಕ್ಷನ್ ಮಾಡ್ಕೊಡ್ತಾರೆ.
Correct. So you challenged that order. So there were.
He does not attach the vehicle to the permit.
Anything, sorry.
ಅಲ್ಲ, ಮಿಸ್ಟರ್ ಲೋಕೇಶ್ ಅವರ ಅವ್ರಿಗೆ ಕೇಳಿದ್ಮೇಲೆ ಅವ್ರ ನಿಮ್ಗೆ ಕೇಳಿ.
Again, the investment was issued by the authority saying that it was minority review. That again he files an appeal before the tribunal. Investment challenge ಮಾಡಿ. investment challenge ಮಾಡಿದಾಗ ವಾಪಸ್ ರಿಮಾಂಡ್ ಮಾಡ್ತಾರೆ.
So 1 second, ಈ annexure A order ಇದೆಯಲ್ಲ, 3/7/2003 to 2023, what permission was granted to the petitioner. You challenged in the review petition.
Yes.
You cannot have any other remedy for this, no other remedy available, only in the appeal by way of review. Review petition. So review petition you filed and that matter was going on, and in the year 2023. Alla 2023. So from 22 to 23 ಏನ್ ಮಾಡಿದ್ರು ಅವರು? Was they running the vehicle?
Then you operated the vehicle, those was started in 2022 ತನಕ ಒಂದು ವರ್ಷ ಓಡಿಸಿದ್ರು.
ಆಮೇಲೆ
ವಾಪಸ್ ಇಲ್ಲ, ಬಂದಿಲ್ಲ.
When was it cancelled? When was it cancelled? ಅದೇ ನಾನು ಕೇಳೋದು. Why there is a set aside of orders ಒಂದ್ಸಲ cancel ಮಾಡೋದು? Then when a review petition is already pending, permit ಹೋಗ್ಬಿಡ cancel ಆಗ್ಬಿಡುತ್ತೆ. So which is that? No, during the pendency of review petition, which is the order passed by the authority cancelling his license? Annexure? ಅಲ್ಲ. ಅದಲ್ಲ, ಇನ್ನೊಂದು. You said one more order.
Annexure D. ಅದು challenge ಆಗಿಲ್ಲ.
Annexure
D. That is not challenge.
Not this. One more order is there. One more order is there of 2022. Yes, sir. Yes.
On the ground, the vehicle was going to have been paid into national account and have not published in government national. The respect number 3 permission. RP number 167 and
Correct, huh? Yes. One nimisha, the respondent number 3 Parameshwara.
Yes.
And respondent number 2 Parameshwara in review petition, being aggrieved of the cancellation of his permit by order dated 3/4/2003, had preferred an appeal 222 of 2017. That has been set aside. So his cancellation was set aside.
On 28 May 2017, the stand number 2 on 25 the respondent number 1 observed the rule of the power. The permission and granted the same along with the requirement of the vehicle to produce the vehicle document.
So that is not done.
First note as requirement to permission without as ordered by the court 15 May 2001 issued an enforcement and order for permission and not comparing the order both of that is named the said endorsement was challenged by the permission permission with appeal number 2 of 2020 and this is the line order including the and demanded the matter to the authority and directed to legal system on 19/4/2020. Accept the same and renew the petition. Obtain endorsement of renewal permit by paying company fees in the Permit should have been put an operation as on 18/2000. Not what they would like to go to EC. On 19/2000, number 2 had to be and no reputation vehicle had to be today. The court said that 18/2000 for the
Yes, Mr.
after this lordship, that was set aside the election A. Then remaining matter to the authority. Not remanded. What is it? In the interest of the lordship, after passing this order, people after passing the order, your lordship, subsequently, your lordship, the connection B, without placing the subject, without placing the subject, I say, your lordship, authority issued this endorsement, that is subsequent. That too without resolution.
But that order has been still there now.
That order is still there.
But then that is not challenged by you.
Challenge. So I have to challenge you, but your lordship,
What
I want
happened?
this order and this the parliament. What's more into?
Then you should have done it immediately.
I mean, what time you know, not go. The subject.
Why such orders, inconsistent orders ಅಂತ ಕೇಳೋದು?
You ಏನು ಮಾಡ್ತಾರೆ authority ಅವರು ಬೇಸಿಕ್ ಸಬ್ಜೆಕ್ಟ್ ಅನ್ನು ಮೀಟಿಂಗ್ ಅಲ್ಲಿ ಇಟ್ಟೆ ನಮಗೆ ಗೊತ್ತಾಗ್ತದೆ ನೋಟ್ಸ್ ಬರ್ತದೆ
Because
resolution ಮಾಡಲ್ಲ ಇದು ಡೆಲಿಗೇಷನ್ ಆಫ್ ಪವರ್ ಅಲ್ಲಿ ಕೊಳಗೆ ಕೂತ್ಕೊಂಡು ಲೇಬರ್ ಕೂತ್ಕೊಂಡು ಮಾತಾಡಿದಲ್ಲ.
but then there is an order now. It has been there in his favor. Whether from 26 to 2020. Audari. Let him file his objections, Mr. Counsel. And objections happily, we will hear it immediately.
But can you see the order? 56. Jara 3. The renewal of permit number 19/98/93. Correspondent to 23. Permits come from 47/3237 is subject to the final result in WP 17 and connected matters pending before this.
What happened? What happened?
This court has dismissed the KSRTC order on 24/2024. Now, my kindly peruse this order. Wrong number endina. Wrong until court can accept my submissions. And in the annexure A also, specifically petition was observed 46/504 of 2017, pending before the High Court, interim orders and renewals are granted by authorities in Karnataka. Renew of the 25/10/2017 interim direction issued by this court. Yes.
You can take all the centers.
It is not an endorsement, my lord. It's a resolutional endorsement. It's a delegation to secretary issued under the KV rules 55.
See, now that renewal of permit of yours
Yes, my lord.
is subject to the final result of this.
Yes, my lord.
So what happens now?
No, that is dismissed. KSRTC
No, why-
challenging notification dated 28/9/2017 has been dismissed and it is in the favor of the private operators.
Then why are you before this court?
No, because for the reason you may kindly prescribe, certified copies are dated 10/6 of that number. Though Tribunal has passed the order on 8/11/2023, certified copies are not issued.
But
That is
now,
the reason.
but now why are you before this court? Already this court said, the review petition said that it would be subject to the final result of the.
Yes, my lord.
Now, in light of the dismissal of this, what happens?
It will be done from that.
Then why are-
Granted by the RCA confirm. Because if
Then-
they don't clear that,
Then why are you before this court? You did not even file this.
order has been passed now, 24. This order has been passed by the Honorable High Court. Now, in the month of April
24/4/2024.
Now, if
The
you,
tribunal order was passed on 8/11/2023. 6 months early.
so then you say that in light of this, now
That
the,
is my contention also.
now we have to dispose of this petition now in light of this order.
My submission is you are trying to remand the matter to tribunal or RT, no objection.
RTA na, yeah, can
Or
R1.
tribunal, because I will challenge this tribunal only. Otherwise, your lordship may kindly remand the matter to tribunal itself.
No, we cannot remand the matter to anybody because there is an order of in the by the tribunal
Yes.
holding that the order of renewal of permit of the petitioners would be always subject to the result
Yes.
of this. This writ petition has been
Is the
dismissed.
petition?
Then what happened?
I appear on behalf of the.
Have you taken notice?
CSRTC.
Have you taken notice? Have you taken
He has
notice?
not made statement, he
Then
has not taken
Then
notice. He cannot argue in the
Yes, Mr. Bandari. Mr. Bandari, you have to look into this order of this. Hmm.
This is 19 As per the government of the Celestial, 8% of the true government. Government should have taken the profit. Anything to them. Operate person.
ಇದು ಯಾಕೆ ಮಾಡ್ಬೇಕು?
Wrongly passed the motion.
Wrongly passed.
No, wrongly passed. After the 28, no, 28 but in 17, I want to, that is still pending before the court.
Then what is this now? This has been disposed of.
That was discussed.
Then that is the result ಅಂತ ಹೇಳ್ತಾರೆ ಅವರು. Subject to the result.
For his clarification, you may kindly put page 17.
You have served the copy on the caveator?
Yes, 29 itself, I have said.
Harish Bhandari, Tenant Council acknowledges the receipt of the writ petition papers. Hence, the office note regarding non-serving of the copy on the caveator would not survive.
One more.
Respondent counsel, the caveator seeks time to file his statement of objection. Yes, at request. ಅವ್ರು ಇದ್ದಾರಾ ಇದರಲ್ಲಿ ಪಾರ್ಟಿ?
That is also by petition 137. I'm not going to say, but he has not taken.
Now he is taking notice for who appears for R1 and R2. CGP to accept notice for respondent number 1 and 2. Harish Bhandari has entered caveat for respondent number 3. So and so council undertakes to file power for respondent number 4. Yes. Respondent number 2, 3 and 4 are granted. How much time you want? 2 weeks to file objections. List this matter on 25th.
Government agreement can kindly be instructed. Defer the matter. Just before the RTA. In view of this tribunal order, they have kept the matter. On 18th.
Not to defer the matter. Huh?
Defer the matter.
You get instructions, Mr. Gold. Let him get instructions. No.
There are holidays there. For day after tomorrow, Monday. That's the reason.
Yes, we will see.
Or it may be called on 17th.
17th, Mr. 18th. 17th, actually instructions. Don't pass any orders, Mr. CGP.
Vehicle has been stopped.
No, 1 minute. Don't pass any orders. Instruct your consent of.
R1. Yes, that is another objection.
We will see. The matter meeting nalli pending idea. What is it?
18th,
When the counsel for the petitioner submits that the order passed by the appellate tribunal in review petition number 137 bar 2022 and 146 of 2022 is placed before the respondent number respondent number one, Regional Transport Authority, in a meeting to be scheduled on 18th September 2024. The respondent number one, to hear the parties, but to hear the parties, however, not to pass any orders pending consideration pending consideration of this petition.
Subject to the petition.
ಮತ್ತೆ ಸಬ್ಜೆಕ್ಟ್ ಯಾಕಂತೀರಾ? ಅಲ್ಲ ಹಿಯರ್ ಮಾಡಿ ನಾಟ್ ಟು ಪಾಸ್ ಆರ್ಡರ್ಸ್ ಅಂತ ಹೇಳಿ defer in passing orders pending consideration of this petition.
Permit number.
Huh?
Permit number.
ಎಲ್ಲ ಅಲ್ಲ what is placed review petition is once the petition is placed everything comes under that ಅಲ್ವಾ? Yes, Mr. Narasimhan. What happened? Settlement aita? Your senior said there is possibility of settlement. I think the right of residence. So till her lifetime, you said that she wants to reside in the premises. Then what is wrong? Then set file of compromise. Pass out. What should we do if the counsel does not come? It abates. Since the counsel for the appellant has appeared, the order directing the matter to be listed for dismissal could not arise. Learned counsel for the appellant submits that the sole appellant has died long back. Next, no steps have been taken to bring the loss of the deceased appellant. The appeal stands abated. Yes, what is your submission? Where were you yesterday? What is the documents you want in the second appeal? Alright, why do you require paper book in this? Records are available.
Got an argument extensively yesterday. The counsel will be present also, but be able to be present before my lords. But after hearing.
Have you issued the notice to him? Have you noticed? Did you receive the acknowledgement?
Should be all minutes.
Returned. No, have you written a notice to them indicating that you want to retire from the case? We'll keep this as further hearing only. We will issue notice to the memo for retire. The matter is heard in part. For want of appearance of the respondent, the matter is adjourned from yesterday to today. When the counsel for the respondent has filed a memo for retirement, stating that the responding counsel wants to retire from the case for want of instructions. Where is the acknowledgement? You have to produce this along with that. Well, you have to also state in your memo of retirement, notice issued to them, the acceptance of notice by them or refusal, whatever it is. You have to state all those facts. How are you to accept this memo for retirement? It's such a bald Is a permissible. Possible. 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 Next is for the dictation agreement. Dictation agreement. Other hearing agreement. ಇದನ್ನು ಕಂಪ್ಲೀಟ್ ಮಾಡೋಣ dictation. Dictation.
Petitions number 24.
Both the appeals are taken up together as they arise out of the common judgment and decree. In OS 112 of 2000, in judgment and decree in RA 39 of 2013 and 40 of 2013 on the file of the Senior Civil Judge and JMFC at Kunigal, First Appellate Court. Confirming the judgment and decree in OS number 112 of 2005 and 182 of 2005. Herein on the file of the Additional Civil Judge and JMFC at Kunigal, referred to as trial court for short. The parties herein are referred into. The appellant is Boraya, son of late Siddhaya. Defendant in OS 112 of 2005 and plaintiff in OS 182 of 2005. And the respondent is Malesh, son of Lingappa. Plaintiff in OS 112 of 2005 and defendant in OS 182 of 2005. The suit property in both the suit is the scheduled property in both the suit is survey number 45 measuring 1 acre 20 guntas, including 1 acre 20 guntas with the boundaries mentioned in the schedule. Herein referred to as scheduled property. The plaintiff Mahesh Malaysia in OS number 112 of 2005 contended award that the suit scheduled property are the self-acquired property of the plaintiff, having purchased under the register sale deed dated 27/4/1970 for a valuable consideration of rupees for valuable consideration. It is averred that the Tirumala Shetty, the vendor of the plaintiff, had purchased the property from the previous owner by Siddhaya on 14/6/1964 under the register sale deed, and he enjoyed the property as the owner. Before the execution of the sale deed in favor of the Malaysia plaintiff on 27/4/1970, Tirumala Shetty had mortgaged the suit property for rupees 100 in favor of Kada Shetty. It is contended that in the sale deed of the plaintiff, Malaysia, it is mentioned that the Malaysia shall discharge the mortgage by making payment of ₹100 to Kada Shetty. It is further averred that at the time of execution of the sale deed in favor of Malaysia, Malaysia had paid 1,400 to Tirumala Shetty, and the Malaysia was under the obligation to discharge the mortgage of the scheduled property. It is contended that it is further stated that after the demise of Kada Shetty, the wife and children filed OS number 114 of 1973 against Malaysia plaintiff for payment of the mortgage money, and the suit was decreed on 18/8/1973. Thereafter, the Malaysia plaintiff has paid the mortgage money to the LRs of Kada Shetty, and mortgage has been discharged. Further, that he is the absolute owner in possession of the suit property. The defendant, Boraya, the defendant Boraya in OS number 112 of 2005 and plaintiff in OS number 182 of 2005 contended that the scheduled property was purchased by his father, late Siddegowda, son of Kempegowda, under a register sale deed 3/5/1902, and that he is the absolute owner in possession without interference. It is stated that totally his suit survey number was measuring 4 acres 17 guntas, including 2 guntas Kharab land, and his father had mortgaged the property, which was redeemed by Boraya by making payment of premium amount in the year 1964. Further, that a partition in the joint family, the scheduled property has been allotted to his share, and the mutation has been effected, and he is in peaceful possession and enjoyment of the suit. The trial court, next paragraph. The plaintiff Malaysia filed rejoinder in OS number 112 of 2005, contending that bringing the genealogical tree of the parties, and contending that late Siddegowda, son of Kempegowda, is not the father of Boraya, defendant, and he is the great grandfather of Boraya, and the father of Boraya is Siddhaya, as mentioned in the genealogical tree. The trial court, on basis of the pleadings, framed the following issues in OS number 112 of 2005 and OS number 182 of 2005, which reads as under. Page number 15 and 16. Both the suits were clubbed together, and the plaintiff, Malaysia, examined himself as PW1 and 4 witnesses were examined as PW2 to PW5. Marked documents at Exhibit P1 to P35. On the other hand, the defendant, Boraya, examined himself as DW1 and 1 witness as DW2 and marked documents at Exhibit D1 to D23. The trial court, on basis of the pleadings, oral and documentary evidence, arrived at the conclusion that the plaintiff, Malaysia, has proved that he is the owner, that he is the absolute owner of the scheduled property. And by virtue of the registered sale deed dated 27/4/1970. That the plaintiff, Malaysia, has proved that the suit scheduled property mortgage was redeemed by the plaintiff. 3. That the plaintiff in OS number 182 of 2005, Boraya, has failed to establish that he is the absolute owner of the scheduled property. Next. And the plaintiff in OS number 182 of 2005 failed to prove the mortgage was redeemed on 14/2/1974 by Boraya. The trial court, by the judgment and decree, decreed the suit in OS number 112 of 2005 filed by Malaysia and held that he is the absolute owner of the suit of the scheduled property and restrained the defendant, Boraya, from interfering with the plaintiff's peaceful possession and enjoyment over the scheduled property. The suit in OS number 182 of 2005 filed by the defendant, filed by Boraya, was dismissed. Aggrieved, the defendant, Boraya, in OS number 112 of 2005 and the plaintiff in 182 of 2005 referred appeal before the First Appellate Court. The First Appellate Court, while reappreciating and reconsidering the entire oral and documentary evidence, concurred with the judgment and decree of the trial court. Aggrieved, Boraya is before this court in the second appeal. Court, Learned Senior Counsel, heard R.S. Ravi, Learned Senior Counsel for the appellant, and Nandish Gowda, Learned Counsel, appearing for the respondent, and perused the judgment and decree of the courts below, including the original records. Learned Senior Counsel would mainly contain the following grounds. That the courts below have failed to consider the fact that the purchase under Exhibit D5, the sale deed dated 3/5/1902, was in favor of the father of Boraya, namely Siddegowda. 2. That the courts below failed to consider the encumbrance certificates from the year 1971 till the date of suit, which indicates that in spite of the sale deeds dated 27/4/1970 and 27/4/1970 in favor of the plaintiff, Malaysia, and 14/6/1964 in favor of Tirumala Shetty, no entries were carried out about the sale deeds in the revenue records. It is contended that the registered revenue records are totally silent about any execution of the sale deeds, and there is no title passed in favor of Malaysia in respect of the scheduled property. Next, that the courts below have failed to appreciate the documents produced by the appellant at exhibit D1 to D22 in proper perspective. Next, that the courts below have failed to consider the fact that the appellant appellant had redeemed the mortgage of the suit scheduled property on 14/2/1974, and the appellant was the absolute owner in possession of the suit scheduled property. In support of this submission, learned counsel submit that the appellant had filed IA and the order 41 rules 27 seeking to produce seeking to produce the certified copy of the mortgage deed dated 17/11/1964. Learned senior counsel submits that the appellant had taken a specific stand before the trial court that his father had mortgaged the scheduled property in favor of Kada Shetty. And in order to substantiate his contention, the original document is, in order to substantiate his contention, he is producing the certified copy of the mortgage deed dated 17/11/1961. And the additional document sought to be produced is relevant for the court to pass judgment in the present dispute between the parties. For contra the learned counsel appearing for the respondent, justifying the judgment and decree of the courts below, would mainly contend that the plaintiff, Malaysia, is the absolute owner of the suit scheduled property, having purchased under the register sale deed dated 27/4/1970 from the vendor Tirumala Shetty, who had purchased this property in the year 1960. That the defendant, that the Boraya has failed to establish and misled the court by calling himself as the son of Siddhigoda, when the material and the evidence clearly indicate that he is not the son of Siddhigoda, but the son of Siddhaya, who is being shown in the genealogical tree produced before the trial court. Next, before the courts below. That the courts below, considering the entire oral and documented evidence, has rightly arrived at the conclusion that the plaintiff, Malaysia, has established this ownership over the suit property. And the concurrent findings of facts recorded by the courts below does not warrant any interference under section 100 CPC. and sought for dismissal of the appeal. This court has carefully considered the contentions posed by the learned counsel. The family genealogical tree, for the sake of convenience, is spelled out as under. Page number 15. Page number 15. Do you have the written statement of Boraya? The plaintiff avers that the plaintiff purchased the suit scheduled property under a registered sale deed dated 27/4/1970 from his lawful from the vendor, namely Tirumala Shetty. Tirumala Shetty. At the time of purchase of the property, the plaintiff was a minor and he was represented by his mother, Narsamma, as a minor guardian. The sale deed, marked at exhibit. The sale deed marked at exhibit P1 and P2. It is stated by the plaintiff that the vendor of the plaintiff had received rupees 1,400 for the sale consideration and directed the plaintiff to redeem the mortgage, which was redeem the mortgage and redeem the mortgage. As the mortgage amount was not redeemed, there was a suit initiated by the wife and children of Karnataka Shetty, which came to be decreed. The plaintiff's rights for declaration and permanent injunction in light of the registered sale deed in his favor, executed in the year 1970. The defendant filed written statement contending that the scheduled property originally belonged to his father by name Siddhaya alias Siddegowda, son of Kempegowda. And the survey number 45 was measuring in total 4 acres, 17 acres. And that his father was in peaceful possession and enjoyment of the fruit property. It is contended that the father of the defendant had mortgaged the part of the scheduled property to an extent of 2 acres in favor of one H. Kada Shetty, son of Siddha Basaya, and the same is redeemed by the third son by name Bhairappa, son of late Siddhaya, who is none other than the elder brother of defendant. It is further contended that in a partition effected between the brothers, this property has fallen to the share of the defendant. specific contention of defendant Boraya is that his father is Siddegowda, who is the son of Kempegowda, as could be found from the genealogy. The trial court and the first appellate court held that the observed and arrived at a conclusion that the Boraya in his cross-examination has clearly admitted that his grandfather's name was Siddegowda, and his father's name is Sannaya, who is also called as Siddaya. The first appellate court, while has reappreciated the entire oral and documentary evidence, especially at para number 19, 20, and 21, has held that the defendant Boraya and the plaintiff in OS number 182 of 2005 has failed to establish and prove his title over the sold property on basis of his success. His claim about oral partition is also been failed to be established by the Boraya. The production of additional document is in respect of the portion of the property which does not pertain to the present suit property, scheduled property. Though the defendant contended that it has been mortgaged to one Kada Shetty, the perusal of the averment in the reference statement and the evidence does not indicate that the property which does not indicate that the document which is sought to be produced before this court is the very property which was mortgaged. Is the very property which was mortgaged to Kada Shetty. The document sought to be produced is not necessary, and the application filed by the appellant under Order 21, Rule 27 does not fit into the ingredients which are necessary for production of additional documents and liable to be rejected. The trial court and the first appellate court has rightly held that the plaintiff Malaysia has proved his title over the suit property, over the scheduled property. The manner in which the courts below have assessed the entire oral and documentary evidence. This court is of the considered view that the same does not warrant any interference under Section 100 CCC, and no substantial question of law arises for consideration in the present appeal. And this court passed the following order. Regular second appeals are hereby dismissed. The judgment and decree of the courts below stands confirmed. Just publish the plaint and written statement. After this dictation, we will take up your say. The notification which you are producing, right, 2002, that was there when the order of disciplinary authority was passed, and even earlier to that also, right? When the deputy commissioner passed the order. Petitioner. Petitioner is an applicant. Applicant in serial application SLAPPA number 1 of 2009. Filed under 33 2B of the Industrial Dispute Act 1947, IDF for short, seeking approval of the order of dismissal of the respondent from service. The in this Tribunal for short, the file of the Industrial Tribunal, Mysore Tribunal for short, whereby the application under section 33, whereby the application filed by the petitioner was dismissed by the tribunal. Heard the learned counsel on both sides and deduced. Heard the learned counsel on both sides. Learned counsel for the petitioner would urge the following grounds. 1. That the tribunal has erroneously rejected the application filed by the petitioner under section 33 2B without considering that the verification committee, district caste verification committee, DCVC, commissioner, he is a commissioner, right? DCVC is a commissioner. DCVC for short, has arrived at a conclusion that has passed an order that the respondent workman does not belong to scheduled tribe and does not come under the category of parivara, which is not categorized under the scheduled tribe, and the action of part of the petitioner in dismissing the respondent workman is based on the order passed by DCVC. That the tribunal has erroneously relied upon the government order issued by the Social Welfare Secretariat, Social Welfare Department, Government of Karnataka, without considering that the National Commission for Scheduled Castes and Scheduled Tribe at National Commission that the National Commission for Scheduled Castes and Scheduled Tribe at Exhibit A25 has given an endorsement that the caste which the respondent workman belongs cannot be treated as a scheduled tribe either in the state list or in the concurrent list. Next, that the tribunal has erroneously rejected the application filed by the petitioner under section 33 2B without considering the settled principles of law while considering an application under section 33 2B of the IDA. Learned counsel has placed reliance on the following decisions. In support of his contention, learned counsel placed reliance on the following decisions. AIF 1995 Supreme Court, page 94. Kumari Madhuri Patil and another versus Additional Commissioner. 2005 Part 3 SSC, page 241, Cholan Roadways versus MG. Tribunal Sambandham. Next. 2007 Part 5 SSC 336, Additional General Manager, Human Resource, Bharat Heavy Electric. Or contra the learned counsel appearing for the respondent, justifying the order passed by the tribunal would mainly contain that there was a confusion that the caste Parivara inverted comma and Naika are one and the same, coming under the scheduled tribe, comma, inverted comma, as per the schedule, comma, sorry. The appropriate government by the Gazette notification dated 25/4/2004 clarified that the Parivara community was being treated as synonym to the Naika, comma, and shall not be considered as ST, inverted comma, anymore, and further clarified that the appointments made in respect of the persons belonging to Parivara, inverted comma, who had obtained employment under ST quota as Naika, inverted comma, shall be treated as appointment under general merit GM category with effect from the date of the order. Then it council submits, that the government order was passed, and the government order was on 25/4/2002. The order of the DCVC and the petitioner in imposing punishment of dismissal was much prior, that is on 16/5/2009, and without considering the government notification, the impugned order, without considering the government notification, the order of dismissal has been passed, that the tribunal has rightly dismissed the application, rejected the application filed by the petitioner under section 33(2)(b) of the Act. Remember, and that the prima facie case has not been established for the grant of approval by the petitioner, and the same does not warrant any. Having heard the learned counsel for the party, the point that arises for consideration is whether the tribunal was justified in rejecting the application filed by the petitioner under section 33(2)(b) of the Act, the ID Act, seeking approval in the present facts and circumstances of the respondent was initially appointed as a technician. Practically fitter. And taken on regular roles of the petitioner during the year 1989. At the time of appointment on regular basis to the post of technician as practically fitter, by letter dated 1/5/1992. In support of the appointment, the respondent submitted an affidavit and a form of caste certificate and form of caste certificate issued by the Tashildar, stating that he belonged to Naika community, which is described as a scheduled tribe. During the year 2005, caste certificate was forwarded. Caste certificate submitted by the respondent and other co-workers, co-employees was sent for verification to the Deputy Commissioner, DCVC, Mandya District. The Caste Verification Committee submitted that the respondent does not belong submitted that the respondent belongs to the Parivara community, which does not come under the ST category. On the order of the DCVC, the petitioner issued show cause notice calling upon the respondent as to why he should not be dismissed from service on account of his act of producing a false certificate, which is meant for the reserve category. Not being satisfied with the explanation offered by the respondent, the competent authority issued an order on 16/5/2009 dismissing the work respondent from service. After the issuance of letter, dispute was pending before the Industrial Tribunal, Mysore. Accordingly, application under seeking approval under Section 33(2)(b) of the ID Act was filed, and simultaneously along with the order of dismissal. 33(2)(b) of the ID Act reads as under. The idea is that the apex court in the case of stolen roadways has held at para number 12, 18, 19, and 20 as under. The law is well settled that the jurisdiction of the Industrial Tribunal under Section 33(2)(b) of the ID Act is a limited one, and thus jurisdiction under 33(2)(b) cannot be equated with that of Section 10 of the ID Act. The Tribunal, while exercising the jurisdiction under 33(2)(b) of the ID Act, is required to see whether a prima facie case has been made out as regards the validity or otherwise of the domestic inquiry held against the delinquent. And the Tribunal, while exercising its jurisdiction under Section 33(2)(b) of the 2B of the ID Act, was required to bear in mind the legal principles that in a domestic inquiry, preponderance of probability would suffice, unlike in criminal trial, where the proof requires beyond any reasonable doubt is imperative. In the instant case, the respondent was appointed as in the petitioner establishment, and while submitting his application, he has submitted the affidavit at annexure, which is at annexure A7. And the form of caste certificate issued by the Tahsildar at annexure A8. The Deputy Commissioner, the Caste Verification Committee, Deputy Commissioner, DCVC, PR District, issued an order on 10/2/2009 that the respondent belongs to Parivara. At this stage, it is relevant to note that the state government of Karnataka, by Gazette notification dated 25/4/2002, clarified that the yes, this is the state government clarified that the Parivara community has to be treated as a nomen to Naika earlier. It shall not be considered as ST anymore, and the persons belonging to Parivara who had obtained obtained employment under the ST quota as Naika shall be treated as appointment under the general merit category with effect from the date of the order. The notification was enforced when the caste verification committee and the dismissal order was passed by the petition. In the said circumstances, at no stretch of the imagination, it can be considered that a false certificate has been obtained by the respondent for employment, and the dismissal of the respondent from service was justified. The disciplinary authority, without proper application of mind, has passed the order of dismissal. The tribunal, while considering the application under 33(2)(b, has observed and considered the government order, the settled proposition of law while considering the 33(2)(b application, and the prima facie case not being made out by the prima facie. There is no misconduct on part of the respondent. The endorsement of the Government of India based reliance by the petitioner reads as under. The above notification of Government of India indicates that the subcaste Naika does not figure in the list of SC. SCs are STs in the state, and nor it can be treated on par with Naika with figures in the ST list. The said endorsement issued by the Government of India and the next 825 placed reliance by the petitioner is not helpful for the petitioner to contend that the order of dismissal passed by the petitioner was justified. The impugned order passed by the tribunal does not warrant any interference, and the court passed the following order. The petition is dismissed. The impugned order passed by the tribunal stands confirmed. Yes. Ready? You are ready? Non-compliance on paper book and all that?
Objections. Right. Substantial question of law is also objections rather than specific. So at that time, I had not so much on these objections. Now, in other analyses, I have prepared the.
So different suits, different courts and different orders, right? Or it was, no, was it connected? The second, the suit was connected?
Same problem. Dispute is same. One is a specific performance. What she does is the intending owner, the owner sells the property to second defendant files an injunction. He gets an injunction. My suit for specific performance is dismissed. She finds the owner files another suit for permanent injunction that gets dismissed. So there were 3 suits, out of which one got dismissed, that became final. There are 2 suits and 2 appeals.
Please serve the paper book on the. Hello, you have not received the paper book? In that specific performance suit.
Permission specific performance.
That is not admitted.
When the injunction suit was so therefore, I have prepared the paper. I require my lord's permission to pass on.
We have to hear this for admission now. Yes, we will hear this.
How? I'm ready. The paper same agreements and handing over.
Whatever has been produced in the injunction suit would be the same thing, right? Same injunction. So how much time will you require? Because we have got some further hearing matters. You file the paper book. Yes. Appellant counsel in Article 746 of 2016 submits that the appeal is not yet connected appeal is admitted by claiming substantiation of law. Then counsel for the appellant submits that he would, he's filing the paper books in respect of the said appeal or the appellant is permitted and the paper book is taken on record. Yes, yes. 746 of 2016. 19, no? 19. 19, yes. 19 will have. And we have got bench in the afternoon, so it may be not very convenient. 19th we will there. Yes, yes. Yes, we will take it.
Substantial question of law is today.
In,
The injunctions. In case of a confusion on there, or there are also analysis.
yes. Six, 160. Yes. Have you filed an acknowledgement? It has been served on them. Judgment is filed by the respondent counsel seeking to retire from the case for want of interest instruction. And the notice registered poster, registered post, registered notice issued to the respondent has been refused. Is produced along with the memo of retirement. The memo of retirement is taken on record. Then counsel appearing for the respondent is permitted to retire from the case. Issue for court notice to the respondent number 1 to 5, returnable by 30. 30. It has to go and come, right? 15 days, right? First time? 27. 27. Registry to delete the name of H.P. Chandrasekhar from the hospital. Now, please. Further hearing. This number. Will come after the completion. Will come after the completion of the. The government advocate, you have completed. Alva? You forget, we told your senior that. You can come now. At request of MJ Alva, Senate Council, list this matter on 19. Yes, Mr. Chandranna. What to do now in that matter? Correct, you are ready. You are not ready to pay her the amount. Allah, you are not ready to pay the amount to her. Where is your counsel? Where is the counsel? Badrinath? If this is the practice of an advocate, ask him to come in the afternoon. We'll take up in the afternoon after the bench matter. Why?
They should be taken notice. And then they mentioned delaying the earlier correction.
We will take up other file person. We will see that first serial number 6, Madhyan Tarsi.
Court officer? Court officer? Court officer? ಡಿಕ್ಟೇಷನ್ ಇತ್ತಲ್ಲ, ಏನಾಯ್ತು ಕೋರ್ಟ್ ಆಫೀಸರ್? ಸೀರಿಯಲ್ ನಂಬರ್ 25. ಆಗೋಯ್ತಾ? ಡಿಕ್ಟೇಷನ್ ಮುಗಿದೋಯ್ತಾ? ಸರಿ. ಈ ಮೈತ್ರಿ ಏನಂತ ಹೇಳ್ತಾರೆ ಅವರು? ಏನ್ ಟ್ರೈನಿಂಗ್ ಕೇಳೋದಲ್ಲ.
Photo on the court officer. Audible ಇದೆಯವ್ರಿ ನಾವು
ಇದೆ
ಲೇಟ್ ಆಗತ್ತೇನ್ರಿ
ಮುಗಿತಾ ಇದೆಯಾ ನೋಡಿ
ಹೌದಾ ಓಕೆ
Matter pertaining to.
Is it awaiting notice?
Please, my lord.
Others have been represented, right?
Please, my lord. My lord, my name is, my lord, shown as 3 to 4. That's 3 to 14, my lord.
Yes. Await service of notice in respect of respondent number 15 to 17. Learned Counsel for Learned Counsel Sharad P. Magdum submits that he has filed a power for respondent number 3 to 14.
14, my lord.
It is wrongly shown in the cause list as respondent number 3 to 4. Registry to correct and indicate the name of Sharad V. Magdum, Learned Counsel, as the counsel appearing for respondent number 3 to 14.
14. Please, my lord. Now he has to take steps for, my lord, sir. Respond number 2 is concerned, my lord. Respond number 2 is died, my lord, sir.
Yes.
I will take necessary step now. I will file the necessary applications.
Respondent Sharad Magdum, Learned Counsel submits that respondent number 2 has died on.
No, sir. Date is not 2 to 23, my lord, she died.
I will confirm.
Yes, she died.
Appellant counsel seeks time to file application at request. 2 weeks time is granted.
Much of, please.
Please, my lord.
What is that, Mr. Abhijit, you wanted to say? Then that would be a final order, Alva. Let him take notice then. So we will say only Devraju to take notice. This matter on 18th. After that, we'll pass a final order itself. If you grant this temporary connection, it's as good as final order. So first, interim arrangement only for electric connection. Fresh bekadre, you have to take them on. HP Devraju, Learned Counsel, is directed to accept notice for respondent number 1 to 2. Appellant Petitioner Counsel to serve the writ petition papers on the Learned Counsel. This matter on 18 in the preliminary hearing stage. Yes, Mr. Manjunath. Who is the power of attorney holder? Who is he? What did he say? What did he say about the execution? He said he knew all the transaction.
It is in my knowledge, they have delayed one of things. Also to pay this in page 15, PW1, paper 15.
Yes.
I mentioned, they say that the plaintiff in the associate, who is the soft person? He is the husband of first defendant and the father of remaining defendants, so known to this friend of plaintiff K. Manchaya, son of my Buddha. You said in Act door number 2193/4 cross second review Ashok. And upon the recommendation and details by name, the plaintiff has advanced a loan of rupees 80,000 to the said named Hyundai for legal necessities from 10/6/2007 of his family, and he had agreed to repay the loan amount along with 18,000 and executed an on remand power and between. After the death of the negotiation, when people accommodate the stated the approach to the defendant.
Okay, there is a cross-examination to the effect that
Examination, no opportunity and not.
why, what is the order sheet? How many times opportunity was given to you? Order sheet, Katie, where is the order sheet? The order sheet is. ನೀವು ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಬೇಕಾಗಿತ್ತು that you have no authority to depose on behalf of the plaintiff. You have no authority. You have no competency ಅಂತ ಹೇಳ್ಬೇಕಾಗಿತ್ತು. Okay. 14/3/2012 he was present. Then again on 22/3/2012 he was present. When did your husband die? Who nine? ಮತ್ತೆ ಅವಾಗ this is in the year 2012. He was represented. He was represented. Opportunity ಕೊಟ್ಟಿದ್ದಾರೆ ನೋಡಿ 4/3/2012 she was present. He was present. Then dependents were called on 22/3/2012. And then 3/4/2012 again. Both the counsel and you and the defendant was absent. What to do then?
It is created one document as the auto talk taken in 2 months before. 2 months before the document has been created after he died in the year 2003. The earlier that 2 months before.
When was the deed executed? You have filed your written statement. What is your contention in your written statement? When did he die, you said? 2000?
Written statement at page 7.
Page 7.
Government made in two of the case. That one made in the year of the husband of certificate and the father of the Indian independence for going to the now when the brother is saying it from the school in the workforce and it was also in the form of
Yes, we will remand the matter. Remand the matter to the trial court for fresh consideration. From the day and an opportunity to the defendant to cross-examine PW1 and lead evidence. Yes. The defendants are before.
The law was passed with the time of 50% deposit is the should be good 50%.
Defendants are before this court, the regular second appeal, assailing the legality and correctness of the judgment and decree. Whereas in RA, 167 of 2012, additional on the file of the additional senior civil judge, first additional senior civil judge and CJM Mysore, referred to as appellate court for short, dated 9th December 2015, confirming the judgment and decree in OS 1530 of 2009, dated 13th April 2012, on the file of the first additional first civil judge and JMFC at Mysore, herein referred to as trial court. Three facts of the case are that the plaintiff sued for recovery of rupees 1,13,520 with interest at the rate of 15, 18 with interest at the rate of 18%. The plaintiff contended that the husband of defendant number one Dundaya, was the friend of the plaintiff. Was known to the friend of the plaintiff, Manchaya, and on his recommendation and intent, the plaintiff had advanced a loan of 80,000 to Dundaya for his legal necessities on 10/6/2007 and executed an demand pro note and the consideration receipt agreeing to repay the loan amount and interest thereon whenever it is demanded by the plaintiff. That the Dundaya expired on 2/9/2007, leaving behind the defendant as his legal heir. When the plaintiff approached the legal heirs of Dundaya and informed about the execution of the demand note on 10/6/2007, the defendants had agreed to return the loan amount along with the interest. However, in spite of the repeated demands and requests made by the plaintiff, as the defendants did not repay the loan amount, the legal notice was issued. Did they reply? Did you reply? What did you reply to the notice?
Not taken loan, not in
Where is that?
It's 29 to 37. It's 29.
There is your reply.
33.
Your Rajamma. Yes.
Legal notice
to repay the loan amount of rupees 80,000 along with interest at the rate of 18% per annum. The defendant replied to the said notice denying the claim made by the plaintiff. And the plaintiff instituted the present suit for the recovery of the suit made with future interest. Next slide. On notice, the first defendant filed written statement inter alia denying the plain governments and contending that late Dundaya had never executed the demand pro note or the consideration received, either by receiving the loan amount nor made any demand to the plaintiff in light of any financial difficulty. Before the trial court, the power of attorney holder, special power of attorney holder of the plaintiff by name Manchaya was examined as PW1. The defendant did not cross-examine the plaintiff PW1 nor let in any evidence. The trial court and directed and held that defendants 1 to 5 are jointly and severally liable to the which was claimed amount of rupees 1,13,520 with interest at the rate of 6% per annum. The trial court had not given sufficient opportunity to the appellants by defendants to cross-examine EPW1 and to lead evidence on their behalf. And the decision passed by the trial court has resulted in miscarriage of justice to the appellant defendant. The first appellate court observed that the order sheet of the trial court speaks the truth in voluminous and the contention of the defendants that they were not given sufficient and proper opportunities was not accepted by the first appellate court, and by the judgment and decree confirmed the order of the trial. When a counsel appearing for the appellant would mainly contain heard the learned counsel for the appellant. Though the notice is served on the respondent, he has chosen to remain absent. This court, while admitting the appeal on 4/4/2023, has framed the following substantial question of law. At the time of argument, additional substantial question of law is framed as under whether the appellant by defendant was afforded sufficient and reasonable authority to cross-examine PW1 and lead evidence on their behalf, and whether the denial of opportunity has led to miscarriage of justice warranting any interference by this court. Not on the section. So the notice is being issued, the notice is served on the respondent, they are choosing to remain absent. Reiterating the various contentions and grounds made out in the appeal memo. The learned counsel for the appellant mainly contend that the judgment and decree of the courts below is erroneous and opposed to principles of natural justice. And would submit that the appellants had filed the written statement. However, the appellants, defendants were not afforded sufficient opportunity to put forth their contention by cross-examining PW1 and reading evidence of the defendants. And for the said reason, the judgment and decree of the child court and the first appellate court needs to be set aside, and opportunity needs to be accorded to the appellant's defendant to prove their case. On perusal of the order sheet of the child court, it indicates that on 7/3/2014, the PW1 was absent. The matter was put adjourned. On 14/3/2012, PW1 was present. The defendants and their counsel were absent, and the cross-examination of PW1 was taken as nil. On 22/3/2012, the matter was posted for defendant's evidence. As the defendant's counsel was absent, as the defendant and his counsel were absent, the defendant's evidence was taken as nil and posted for on 3/4/2012 for arguments. The appellant counsel was heard, and defendant counsel was absent, and the matter was posted for. Defendant counsel was absent, and his arguments were taken as not adduced, and the matter was posted for judgment. The perusal of the order sheet would indicate that the entire process of leading evidence took place within a period of 1 month. Within a period of 1 month. And the defendants were not given sufficient opportunity to cross-examine PW1 and leave their evidence. The learned counsel for the appellant submits that the tow note alleged to be executed by the deceased Dundaya was on 10/6/2007, and the Dundaya died within 2 months of the alleged demand tow note, and the same has been specifically denied by the defendant in their written statement. And an opportunity needs to be granted to the defendants to prove their contentions, our government's raised in the defense statement. There is a sufficient force in the contention of the learned counsel appearing for the appellant. And further, it is submitted that PW1 is the power of attorney of the plaintiff, who is nowhere connected with the transaction. Neither he is well versed about the transaction alleged to have taken place between the plaintiff and David Dundaya. and an opportunity needs to be granted. There is sufficient proof in the submission made by the learned counsel appearing for the order. And accordingly, the additional substantial question of law framed by this court is answered in favor of the appellant. The substantial question of law framed on 4/4/2024 is not answered by this court as the matter requires to be remanded for fresh consideration before the to be trial. And this court has the following order. The regular second appeal is allowed in part. Matter is remitted back to the trial court for fresh consideration in accordance with law. In accordance with law. Allowed in part. The judgment and decree of the courts below are hereby present. The matter is remitted to the trial court for fresh consideration in accordance with the defendant. The appellant is permitted to cross-examine PW1 and lead evidence. The trial court to afford opportunity to the defendant to cross-examine the plaintiff and the produces evidence by affording sufficient support. The appellant to appear before the trial court on 15-20 days. 15th October or before the other petition. 15th October 2024. Since the respondent has not appeared before the court, the trial court to issue notice to the respondent plaintiff. That's all. It is ultimate loss for you if you are unable to prove the pronote. Power of attorney. We have not expressed anything on merits. This court has not expressed.
The system power of attorney cannot act in the place of the principal and he cannot give evidence. The principal place. Principal has to come because we have written reply. So
In support of his contention, the person has placed hands of the following decisions. Office copy ಕೊಡ್ತೀರಲ್ಲ ನಮಗೆ following decisions. All the contentions are kept open on final order. This court has not expressed the merits or demerits of the case. All the contentions are kept open to be urged before the Yes. Yes, Mr. Chandrana. What is it? Where is the counsel? I should delete some other. Let her go to the legal services. The counsel for the respondent has not appeared. So the matter is called twice. Respondent is present before the court. She pleads that she needs to engage another counsel. She is referred to the legal services authority. And on such appearance by the respondent, the legal services authority to provide an advocate, a legal aid to the respondent. Yes. Is this matter on? 20th. Let she take legal assistance. Mail ಕೊಡಿ ಅವರಿಗೆ. Amount in deposit to be transferred, right? Amount in deposit to be transferred to the trial court. So it is nothing here. It is not here. In light of the remand, the amount, in light of the remand, the court fee to be refunded under section 66 or 64, 66 of the Karnataka Court fee and fee violation to the appellant in accordance with law. Is any other matters which the councils are ready? Because we have some other function here. Is which is the matter, Mr. Counsel? Who is ready? Small matters. Okay. 1 second. 14. Who is there in 14? What happened to the settlement, Mr. Counsel? Narsimhan? Is this on 19? Yes. Which is the matter you were mentioning? How much time you want? How much time you want to vacate? Eviction. Both the courts are. Additional document, how can we consider in the second appeal? And now you are the. No, he is the defendant. He is the defendant. And your suit is for eviction.
Eviction was dismissed.
What was the ground? On what basis he's been? He's a tenant. And he says he's an agreement holder. Did he file? Did he file a suit for specific performance of fund? Then what is your right to stay in the premises? Not even a day. What have you filed a suit for specific performance? The council, have you filed a suit for specific performance? No, have you filed a suit for specific performance? So you said you are not the tenant. You said now. Then see, take it from this court. You will be only given some time to vacate the premises. Not both that. Heard the learned counsel for the appellant to vacate. When will you vacate? Yes, this court is asking you, when will you vacate? When was the suit filed? You don't know. When was the suit filed? 2013. You are claiming on an agreement of the year 1991. From 24 years, 34 years, you have not even looked into the specific performance. We will enforce that.
I don't know all these facts. In a Victorian, I don't know. But
you are a Bangalorean, huh?
Yeah.
Bangalorean ke baral why kar rahe hain? You have to say you are not acquainted. 19. In the meanwhile, the appellant counsel to file amended cost title and amend the cost title. Otherwise, appeal would be dismissed. 19. We are not even giving you more than 1 week and you want us to adjourn it to 10. Yes. If the counsel should be present, mention on the next date. 18. Devendrappa. Time. Where was the senior? Both the senior counsels are there. This. What is the suit for? You are the instructing counsel, right? And why are you taken by surprise when the court is asking you? Why you couldn't hear? What is the suit for? Partition. You are the defendant. You are claiming self-acquisition. Yes, we'll take it up on 19. 19. 19. Yes, Nagarajappa. Yes, Mr. Narasimhan. You don't appear in the settlement matter. What happened then to the settlement?
Four items of. What I'm saying is, it is the liquid. I'm not getting it. They are all the children.
You are the mother. Look at the plight of the mother. Where is the children? Where are the children? How many children she has got? All sons.
They've got two sons and one daughter.
Where is the daughter? Daughter is also not taking care of her.
One not taking care.
How many children? All the children are there before the court. Where is? Look at him. ಎಷ್ಟು ವಯಸ್ಸು ನಿಮ್ದು 38. ಎಷ್ಟು ವರ್ಷ ನಿಮ್ಮ ಅಮ್ಮ ನೋಡ್ಕೊಂಡ್ರು ನಿಮ್ನ ಮರ್ತ್ ಬಿಟ್ರ ಇಲ್ಲ ಯಾರಂತ ಗುರ್ತಿಲ್ವಾ ಅಮ್ಮ ಅಂತ ಗುರ್ತಿಲ್ವಾ ನಿಮ್ಗೆ Why dispute regarding the relationship?
She is Objection.
And
the first wife of one Nagendra. Specific case made of certificate number 2, 3 and 4 are considered. Of Nagendra and Objection. Plaintiff and her husband.
She says they are the children of.
They are the children.
And who is this Lakshmi?
Lakshmi is the second wife of Nagendra.
And they say that Lakshmi is that my. Wonderful. If they can, for the property, if they can say that she is not the mother, not in this janma. In janmanalli nimma punya siglikki sadhya illa. To take a property, you are disputing the very paternity of your mother. What is that according to them?
Now what they say is, they say that they give you 2 quintals of land and create a life interest.
When is the date of birth of defendants 2 and 4? The first appellate court set aside the judgment and held that she is not the wife of Nagendra and not the children of, they are not the children.
The relationship between Nagendra and Objection was not proved as the head with superstitions.
What is the document to show that she is the wife of Nagendra?
Five documents, 6 documents,
RTC, what is that on? No, now there is a relationship dispute between the plaintiff and the defendant. Yes. Is it not? They say they are not the children of this plaintiff. To indicate that they are the children of the plaintiff, what is the documents you have produced? Or rather the wife of Nagendra?
To show that I am the wife of Nagendra, I have produced.
P1. Okay, now see, she says that they are the children.
Yes.
There should be some document to show. What is the document to show that they are the children? And what is their document to show that she is not the mother, rather they are the children of some other lady? They are born to somebody, right? Yes. in Manit Bandra.
Now, I have produced the documents, my lord, to show that I am the wife of Nagendra. Is that to show that they are the children of Lakshmi, and no document is.
Birth certificate no document. They disputed they are the children. She said they are the children of hers. Any witnesses examined?
What four witnesses examined? That are examined, my lord, four witnesses apart from me. Comes one of my who is checking out my husband again. He was a single day. It is the Ashwat, my lord, is my brother. PW4, my lord, is my mother. And PW5 is one of the.
And the second wife has got only one female child.
Yes, sir. Dependent number 5.
She has no other children other than dependent number 2 to 4. It is a specific case.
Yes.
And where is the disputed written statement? Where was he working? Nagendra. And did they get any compassionate appointment?
So what happened is one P&SC proceedings were initiated.
Yeah.
That P&SC proceedings, unfortunately, I did not contest.
She was made as a party.
Made as a party.
And then what was the ground taken by them? She is not related, or what was it? What was the ground taken?
So that's such they said that they have made her a party.
1996. That P&SC.
3 of 1996. Was or not? I think the only reason married for because of reverse
You have got the P&SC copy? What did they say in that P&SC? Page number? Huh. They say that first petitioner claims to be the wife of deceased Nagendra, who is employed. They also claim, they say that she also claims to be the wife. They don't say that she is the mother of the wonderful. Petitioner number 2 is the mother of Nagendra, Malamma. And respondent is Vanaja. So both of them are not their mother, or Vanaja or Lakshmi. So they are not born to anybody. They have come from top. ಯಾರಿ ನಿಮ್ಮ ಅಮ್ಮ ಅಂತ ಹೆಸರು? ನಿಮ್ಮ ಅಮ್ಮನ ಹೆಸರೇನು? ಮತ್ತೆ ನಿಮ್ಮ ಅಮ್ಮ ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ P&SC ನಲ್ಲಿ. ನಿಮ್ಮ ಅಮ್ಮನೇ ಅಲ್ಲ, ಲಕ್ಷ್ಮಿನೂ ನಿಮ್ಮ ಅಮ್ಮ ಅಲ್ಲ, ವನಜಾಕ್ಷ್ಮಿನೂ ನಿಮ್ಮ ಅಮ್ಮ ಅಲ್ಲ ಅಂತ ಹೇಳಿದ್ರ. ಈಗ ಬೇರೆ ಸ್ಟ್ಯಾಂಡ್ ತಗೋತೀರಾ? ಲಕ್ಷ್ಮಿನೂ ನಿಮ್ಮ ಅಮ್ಮ ಅಲ್ಲ, ವನಜಾಕ್ಷಮಿಯನ್ನು ನಿಮ್ಮ ಅಮ್ಮ ಅಲ್ಲ. ಯಾರು ನಿಮ್ಮ ಅಮ್ಮ? Who is your mother? You tell your client, we will allow this appeal. We will allow this appeal. And they will not get any share. Let him go to Supreme. If he wants to dispute the relationship of a mother, he claims both of them are not his mother, nor in the petition of P&SC and not before this in the civil court also. So tell your client. When we are telling you something, you at least take note of that. Yes. Yes, now what is the difference now?
So what they say is they'll give you 2 gunters of land. They say item number 1, measures amount for 55 gunters.
Item number?
1. Measures amount 55 gunters. Now 1 share is what the plan for 11 gunters of land is what it costs. It's the life interest that she.
Why do you want life interest? We will give you 11 guntas of land only. You take and go. Let them sit where they want. ಅಷ್ಟೇ ಮಾಡಿ. ನೀವು 2 ಗುಂಟಾನು ಕೊಡಬೇಡಿ, ಲೈಫ್ ಇಂಟ್ರೆಸ್ಟ್ ಕೊಡಬೇಡಿ, ಏನೂ ಕೊಡಬೇಡಿ. We will give her. We will give her share. ಅಷ್ಟೇ ಮಾಡಿ. Why should she beg before you to give some life interest? She is not even asking for anything. She is asking a life interest in a property for her to stay in the property. Yes. Ready, we will dictate the order now itself. What is the substantial question of property? If this is the attitude of your client, you tell your client we are going to decree the suit of hers. Tell your client. The plaintiff is before this court in the second appeal, assailing the judgment and decree in RA. What he will talk? What will he talk? Where is your senior? We will pass orders, you get your senior. We will pass orders. Let you get 1/3 share, half share. 1/5 share. There are documents to show she is the wife of Nagendra. Let them say that she is not the mother. We are not here to decide their relationship. She is the wife of Nagendra. She has to be given share. She is the first wife. Second wife, not entitled. And if they are claiming to be the children of second wife, they are also not entitled because the marriage was during the subsistence of first. So that also they are not entitled. Illegitimate children, they'll be getting only in the share of the father. Notional. Hange ಮಾಡ್ತೀವಿ ಈಗ. 1/5 ಏನು ಕೊಟ್ಟಿದ್ದಾರಲ್ಲ, that also should not be entitled. She'll get half and they will get, in half they'll get 1/10 share. 1/10. Yes. What do you want me to do? Pass over at 4:15. You ask your client to tell him that what is the court intending to do. I don't know whether he understood what this court is trying to tell. So if the marriage of the second lady, Lakshmi, is during the subsistence of first marriage, then she would be entitled to only notional. That is, she will not be entitled. The defendants 2 to 4, because they are disputing the that she is the mother. If they say that she is the mother, they would be entitled to equal share. After her death, they'll be getting share in the property.
Same thing to be correct.
Is it not?
Same things to be correct.
See, Nagendra, Vanajakshmi, then plaintiff, defendant is Kubendra, Nagamani, and Naveen.
Yes.
Now the second wife, where is the second wife?
Second wife doesn't get anything.
No, now that they are disputing the relation.
Yes.
So they claim that they are not the children of her. So assuming that they are the children of that Lakshmi, then they would be getting notional partition in the share of Nagendra.
The section 16 nevertheless.
Correct. Nevertheless, first there has to be a notional partition between Nagendra and Vanajakshama. That is Vanaja Lakshma. Vanaja Lakshmama. Vanajakshama. That is half and half. Half. That is how it is. Revana Siddhappa. Correct. They are to be treated as legitimate children, but they would get share in the Nagendra's share, not in not equal to the Vanajala. So Nagendra and this Lakshmamma together they would be getting half share, and in the half share of Nagendra, the Vanaja Lakshmamma and the other 3 children together would get, that is 4. Half nully 1/8 share. They will get only 1/8 share. That is how we will do now. Yes, 1/8 share. 1/5 ಇಲ್ಲ ಅವ್ರಿಗೆ ಅಲೋ ಮಾಡ್ತೀನಿ, ಹಾಫ್ ಶೇರ್ ಇವ್ರಿಗೆ, ಆಮೇಲೆ ಕುತ್ಕೊಳ್ಳಿ ನೋಡ್ಕೊಂಡು. What is that? No, until you tell something before this court, we are not going to get up from this. We are not going to raise also. This is a special circumstances where children are disputing the relationship of a mother. And when they are claiming to be from the second wife, let them claim, then they will get more benefits. Yes, where is your senior? Huh? 50. 15 ಎಲ್ಲಿ ಮೇಲೆ ಕೆಳಗನ ಬನ್ನಿ ಅಂತ ಹೇಳಿ, ask him to come. Go and get him. We'll dictate by then. Yes, let him know what he's going to get. Yes, ma'am. So this is the proposition. She'll get half. We are going to pass an order that she'll get half and they'll get 1/8 share. Without settlement go barala. They will also not. Yes, pass over for 5 minutes. Now, which is that other matter? Nagrajappa. Where is he, Nagrajappa? 19. 19. Christopher Neol. ಇದು 19th ಹಾಕೊಳ್ಳೋಣ. Shivaji Rao, you are ready? Huh? Both of you all are ready? So 19th will take. We have some function now at both. Yes, Mr. Mahesha in other matter. Srinivas and Mahesha. This time is not enough for second appeals. 20. Take your chance on that day. 20. Mr. Counsel, 20. ಇದು ಮುಗಿದ್ಮೇಲೆ ಹೊಸ ಹಾಕ್ಬೇಡಿ. Sign the name. Where is he? ಮತ್ತೆ ಯಾವ್ದಿದೆ ಪಾಸ್ವರ್ಡ್? ಅದೇನಾ? ಸಿದ್ದಮಲ್ಲಪ್ಪನ ಇದು? He will never come. Siddhamallappa will never come. No, his colleague comes. He's Gopi. I thought he is Siddhamallappa. You know, when he will come, we'll wait outside. He on yesterday also he did not appear in one matter. Is it not? You appeared, and then what happened to that matter? DNP. Later on, you came and checked out with the court officer. What happened? You should check, right? You thought DNP ಮಾಡ್ತಾರೆ ಮತ್ತೆ recall ಮಾಡ್ತಾರೆ ಇದಕ್ಕೇನ್ ದೊಡ್ಡ ಮಾತು. That was your apprehension, right? So come and check. That is how the junior has to work. If you don't work at this stage, you will never work. You should know what happens. ಏನಾಗುತ್ತೆ. Court will always feel something different all the time. Should keep watch. You should have asked the court officer what has happened. Did you ask? Did you check the board? Net? ಅದು ಚೆಕ್ ಮಾಡಿಲ್ಲ ಏನಾಯ್ತು ಅದರಲ್ಲಿ ನಾಟ್ ಅಪ್ಡೇಟೆಡ್ ವಿ ಹ್ಯಾವ್ ಅಪ್ಡೇಟೆಡ್ ಎಸ್ಟರ್ಡೇ ಓನ್ಲಿ ಅಲ್ವಾ yes what you want to do now we have only got 1 minute 4:20 with this court will raise we are going to say allowed ಅಷ್ಟೇ allowed ಅಂದ್ರೆ ಮುಗಿದೋಯ್ತು ಈಗ modified half share you make that lady wait that lady where she is look at her plight and the sons are healthy built not able to even look at her. He keeps his hand in the look at him, he's watching from there. Not keeping well. We will not raise only till he goes, till he comes. Making a lady wait, is it not? Now so many ladies are waiting now for your senior to come here. In settlement ಮಾಡ್ಕೋತೀರಾ ಏನ್ ಮಾಡ್ತೀರಾ? Give her what is that her entitlement?
11 guntas.
Half. So how much is it? 21. Let she enjoy the 21 guntas.
There are 4 items of property, 1 house property, 2 sites, and 1 agriculture. Such a nice lady in there.
Let she be till her lifetime. She's not even asking for anything. One mane irlik kodalva ನೀವು. That's why to fight, why to tell you at least, no? Why to tell your client? I mean, what this court is telling is not you. You are telling the client. Give her her house. She's asking for a residence. Where they say they are ready. You are saying no, take 2 guntas, go away. Go away. What she will do with the 2 guntas? Nobody will construct a house also in 2 guntas. Forget Pap, she is the way she will construct. So Council, you are making this court wait for your senior. Look at it. Monday. Tuesday for further hearing or reporting settlement. Aglil Andra, take it from me. This court is going to pass an order. And tell your client half share. Half share kinta 1 paisa 1 share kamila.